Thank you once again for your time in filling the form to share your expectations of this webinar with us. We really appreciate. As I briefly mentioned, we are recording this webinar, so kindly bear with us. And by way of officially starting, again, good morning to you all, distinguished ladies and gentlemen. My name is Dorabo Mamauto. I lead the Freedom of Expression and Digital Rights work at the Media Foundation for West Africa. It's a pleasure to meet you all. I'll be the moderator for today's webinar. But for now, let me do a sort of a welcome, as I have already done, set the tone for the webinar, and then do some introductions. It is with great delight that I welcome you all on behalf of the Media Foundation for West Africa to this timely and important webinar on silencing expression by journalists, activists, civil society organizations, and other human rights defenders through legal harassment. As we may all know, across West Africa, we are witnessing a disturbing trend. The law, which is intended to protect rights and ensure justice, is increasingly being turned into a weapon against those who speak truth to power. Journalists, civil society activists, environmental defenders are finding themselves entangled in lengthy legal battles, not because they have committed crimes, no, just because they are exposing crimes. Strategic lawsuits against public participation, commonly known as SLAPs, are being filed by powerful political and corporate actors with a simple aim of intimidating and exhausting their critics. Also, outdated and overly broad defamation and sedition laws are routinely invoked to criminalize speech that challenges authority. This weaponization of the law is not just a legal issue, it is a civic crisis. When journalists are sued for uncovering corruption, when environmental defenders are dragged to court for opposing harmful land use, illegal mining, destruction of farmlands and potable water, when activists are jailed for tweeting criticism, we lose essential checks on power and democratic space begins to shrink. The chilling effect is real, and we will be hearing about this in some few minutes from some frontliners who have gone through this experience. Many voices are silenced, not through violence, but through fear of costly lawsuits, arrests, or losing their livelihoods. The burden of proof, legal fees, and years in court are often enough to discourage investigative work and community advocacy altogether. Today's discussion will therefore help us to unpack these threats in detail, hear directly from those affected, and explore how legal, institutional, and regional mechanisms can be strengthened to ensure that the law protects, not punishes, those who stand up for truth, justice, accountability, and sustainable environment. We are fortunate today to have with us some experienced frontliners who will share their experiences with us. And we also have some distinguished speakers who will take us through the broad issues I have outlined just a few minutes or seconds ago. So let me take the opportunity to introduce these people so that I will not have to introduce them again when they have to speak or when they are due to speak. First on my list is Mr. Ajibola Amzat. He is the co-publisher of WikiTimes, which is based in Nigeria. He's also the Africa editor of the Center for Collaborative Investigative Journalism. He has served in different roles with prominent media outlets in Nigeria as editor, as managing editor, features editor, among others. His work generally focuses on investigating power structures in West Africa, combating information disorder, and advancing data journalism. He'll be sharing with us some of the legal harassment Wikitimes and its journalists have experienced. We would also have on this webinar another frontliner. He is a lawyer Foromo Frederick Lua. He is a lawyer with the Guinea Bar Association and a steadfast advocate for victims of human rights violations. He's a founding member and executive director of the NGO Le Memdra Putu. I hope I've pronounced it right, which actually means equal rights for all. And in his recent engagement, he has been largely advocating for community rights, especially when it comes to the environment. He'll be sharing with us some of the legal harassment experiences the communities he's worked with have gone through, and some of the cases he has led as a lawyer and also as an activist. Then we'll have Mr. Seth Bokwe, who is an award-winning journalist working as an associate editor at the Fourth Estate. The Fourth Estate is a public interest and accountability journalism project of the Media Foundation for West Africa. He has years of experience in print and online journalism, and he has worked with some of Ghana's most leading media organizations before he joined the Fourth Estate. Over the years, he's led and contributed to groundbreaking investigations that have exposed corruption, abuse of power, and systemic failures in governance. Seth will also share with us some of the legal threats they are dealing with as a newsroom. And like I mentioned, in addition to these frontliners, we also have distinguished and experienced speakers who would be taking us through specific topics. And first, we have lawyer Gloria Ballason. She is a distinguished lawyer and a principal partner at My Legals, which is the Ballason Chambers. She's also the CEO of the House of Justice, which is based in Nigeria. She's a leading voice when it comes to civic freedoms and digital rights in Africa. She has achieved significant successes in several landmark cases in Nigeria, including one at some point against the Inspector General of Police, which she actually won and got damages for her clients. Lawyer Ballason inspires journalists and activists through the courtrooms and the classroom, and also through her columns. She's more like a journalist herself, and she is a member of the West African Network of Activist and Media Defense Lawyers. We are very glad to have her join us here today to share her perspectives on the issue of weaponizing the law against expression. And let me just say a very special thanks to her, to everybody, but to her, because she's been indisposed. She was actually just discharged yesterday from the hospital. But because of the importance she attaches to the subject, she's here joining us to make a submission. So thank you very much. We also have Dr. Dugbeme Kone from Cote d'Ivoire. He is a lawyer at the bar at Cote d'Ivoire. He is known for his staunch advocacy for public freedoms and human rights. As an expert in media law reform in Cote d'Ivoire, Dr. Kone has played a pivotal role in defending journalists and media actors in both civil and criminal courts. He also impacts his knowledge to journalists through his lectures on fair trial and media ethics. And he is also a member of the West African Network of Activist and Media Defense Lawyers, set up by the Media Foundation for West Africa. Thank you for joining us. Then we are also privileged to have Mr. Edetain Ojo, who is the Executive Director of the Nigeria-based Media Rights Agenda. He has worked on freedom of expression and media freedom, access to information, internet freedom, digital rights issues across Africa and across the world for close to 30 years. He currently serves as a member of the advisory network of the Freedom Online Coalition. and he has also served as a former and later a chair of the Board of Directors of the Media Foundation for West Africa, and also a former chair of the Africa Freedom of Expression Exchange, which is a network of freedom of expression organizations in Africa, and the secretariat here with the Media Foundation for West Africa. In 2017, he was conferred with the Lifetime Award for Journalistic Excellence by the Wole Soyinka Center for Investigative Journalism. And in 2018, he was also honored with the Defender of Press Freedom Award by the Nigerian Union of Journalists. Thank you, sir, for joining us. And thank you all for joining and being ready to share your depth, your wealth of knowledge and experiences with all the participants today. We are grateful to each of you because we know you are really busy, but you've made time to join us. So now let's dive straight into the issue at hand. How prevalent is the issue of legal harassment that is targeted specifically as silencing expression? And I'll just once again say, put your comments, your questions in the Q&A feature and they'll be addressed. So let me first call on Mr. Ajibola Amsat, a co-publisher of Wiki Times, so that he shares with us their lived experiences when it comes to issues of legal harassment against journalistic work, against activism in Nigeria and beyond. Mr. Amsat, I hand the microphone over to you. Thank you.
Yeah, thank you. Thank you. Thank you. Thank you. Thank you. I am hearing myself. Do we all need to mute? I don't know, because I can hear the echo of my voice. Can you hear me?
There's a bit of echo and your voice is a bit far away, so if you could just...
I'm wondering why that is.
Okay, I think we can probably move to Seth from the Fourth Estate, and then we'll get back to you while we sort the echo issues out. Thank you. So Seth, just share with us some of the legal battles you are dealing with at the Fourth Estate. Hello, Seth. Okay, I'll then move to Maître or Monsieur Lua from Guinea.
Charlie.
Okay, so Seth is ready. We'll just take Seth's submission, and then when he's done, we'll go back to Mr. Amzat, and then we'll come to Maître Lua from Guinea. Okay, Seth.
Hello, good morning. My name is Seth Bokwe. I'm a journalist with the Fourth Estate. It is the accountability and public journalism project of Media Foundation for West Africa. Our work basically focuses on anti-corruption, health, human rights, and environmental reporting. The Fourth Estate was set up in 2021. And since then, we've done some impactful journalism. I'll tell you a few of them. We've done stories that have saved the country billions of cedis, ensured the highest level of compliance with our asset declaration laws. Sorry. We've done stories that have led to the highest level of compliance with asset declaration laws since 2013. stories that have ensured the restoration of indigenous rights to West Africa's largest salt deposit, stories that have ensured the amendment of a mining law that opened our forest reserve to mining, particularly ones that companies owned by politicians. We've done stories that have prompted parliamentary inquiries and showed policy changes, including the overhaul of our scholarship scheme. But whilst doing this, we've also bought ourselves a lot of trouble. And this trouble has come through lawsuits. I'll give you a few. Last year, we did some work on our National Service Authority, which is an organization that supervises the deployment of young people to serve our country for a year after graduation from school.
Yeah.
Now, before we publish this story,
It's spins.
we have given the National Service Secretariat the opportunity to respond to our concerns, the right to response. Rather, instead of responding to these concerns, they went to court to place an injunction on our story. This was done on our blind side. When this expired, they went back to court again to seek another injunction. When our lawyers responded, then they quickly withdrew. Again, we did a story last year about revenue, 2023 actually, about revenue assurance, a cooked revenue assurance deal that would have cost the state billions of cedis. This story was titled "The 3 Billion Lie." And after the story, the company, Strategic Mobilization Limited, sent us to court, suing for 10 million cedis. It looked as though the 10 million cedis is a threshold that those who seek to stop us from doing our work love to bundle around. And I'll give you a few examples as we go on. Through our lawyer, that case was dismissed initially because they went to court to sue the Fourth Estate, which is a project. They were so much in a hurry that they didn't even do their due diligence to find out that the Fourth Estate is not a media organization, a legal entity on its own. So they went to sue the wrong person. So eventually it was dismissed and they refiled again. And you know what that means. Money, money, money. There's one case that we've been running in the court for the last 4 years. It was our first story, published in April 2023. It was about a church that was allegedly exploiting its pastors, and not just economically, but emotionally as well. So when we published this story, they rushed to court, and we've been sued locally and internationally for this. We've been sued 3 times in the local courts and also in the UK. Now, when in the UK case, for instance, when you can imagine paying your legal fees in pounds, and if you do the conversion, it's not a small amount of money. Eventually, we got some legal assistance in the UK, and when the case went to court proper, this bishop of the church backtracked because he noticed when the case wasn't going his way, he eventually had to back out because it would have cost him a lot of money. So we had to settle out of court. In the case of the local one, we've been in court in the last 4 years. Every single month, we have to go to be in court. You can imagine what that does to our work, the time spent, the resources spent on this as well. And then also there's another case which was recently filed. This is from the National Service story I mentioned earlier, 10 million cedis. Somebody whose name was just mentioned because he was part of the management of the National Service Secretariat from 2017 to 2021. We mentioned to 2019, actually, 2017 to 2019. All we did is to say he was part of the management of the organization within this period. There was nothing alluded to him that he actually did anything wrong, but he went to court for this. He said we should retract and apologize and also pay 10 million cedis on top of this. Then we also have another case. We did this story I mentioned earlier about how a mining law that was supposed to protect our forest reserves, but rather ended up opening the forest reserves for politicians and their cronies to obtain mining leases and mine. When we published this story, one MP, he was an aspiring member of parliament at the time, he went to court to say that we have injured his reputation. And the interesting thing is that he sued us and then he sued our lawyer, Mr. Samson Anyenini, who is a member of the WANAMDEL. And funny thing is, when we filed our response, he abandoned the case. He hasn't responded since. And then also, we've had some attempted lawsuits. I said attempted because the Fourth Estate enjoys some level of goodwill within the legal community. So when these two stories they heard, we actually announced that we were going to publish some 2 stories. These people rushed to court or contemplated going to court, and then we were hinted. So to be able to publish the story or ensure that the lawsuit does not hold us back, we quickly published the story. 2 of them, one on the scholarship I mentioned earlier, and then the other one on the Songo Salt project, which is West Africa's biggest salt deposits. The concession was awarded to a company and denied the entire community, which has for centuries depended on salt mining. When we did our story, the company was furious, issued a number of rejoinders, but before then they were going to court. But we preempted that court action by publishing the story. The same thing with the scholarship story I mentioned as well.
Okay.
But what has been the impact of this on our work? The financial strain. Our organization, the Media Foundation for West Africa, has to bear the cost of all these legal maneuverings, and it's a major cost on our budget line. There's psychological pressure. It is not easy for a journalist to think of going to court. The anxiety, the stress, the fear of facing a judge could lead to a burnout for a journalist. And we have to endure this in the last 4 years. And it also has a chilling effect on our editorial decisions. How do we ensure that we do not end up in courts, or our organization does not, spend so much on dealing with these legal issues? And there is this thing about reputational impact as well. If you're a journalist and you are sued, in the minds of the public, you did a terrible job, irrespective of whether your job has led to saving the public purse or not. There's a reputational impact on you as well. So all this leads to some level of pressure on it. But how are we dealing with this? We know that we can't prevent people from suing us, but we can prevent them from winning these lawsuits. So what do we do to prevent this? To actually hedge ourselves against the cost that comes with this and the damage that comes with it. We have tried as much as possible to have rigorous fact-checking for our stories, well-documented sources before we publish. We also ensure that the stories are well vetted by our lawyers to ensure that when we come out ultimately, you either abandon your case or you will not win. And then also, through training, we are familiarizing ourselves with defamation laws, privacy laws, and so on. We also maintain accurate records of our work, because if we go to court, our notes will count, our recordings will count, and any other thing we use in doing the story will be necessary in defending ourselves. So we have very meticulous record keeping approach.
Thank you.
And as I said earlier, we seek legal reviews for our work constantly. If at any point we are doing a story that has any legal impact, we seek legal advice. And when the story is done, it's sent to the lawyer to vet. Primarily, this is what we've been doing, and this is what we have suffered in the last 4 years. Thank you very much.
Thank you. Thank you, Seth, for sharing these experiences from the fourth estate. The number of suits within 4 years, talk of the psychological and then the emotional trauma, the possible ramification for reputation and all that. Thank you for sharing these with us. And the fact that if you are not resilient, you would end up probably just abandoning the work. Let's hear from Guinea. Let's see what is happening there also. So I would invite Monsieur Lua to take the mic and share with us their experiences as activists as well. Hello, Monsieur Lua, can you hear me? Okay, let's go back to Monsieur Amzat. I'm almost making a francophone now. Okay, so Mr. Amzat, co-publisher at Wiki Times, kindly take the mic and then share your own experiences also with us.
Is it better now?
I don't know, do you have someone with you probably sharing the link or something like that? I think we try to prompt on that one. If someone is sharing the link with you in your space, the person could probably just exit whilst you make the submission, and then the person can come back on. So I think you can probably just try again. Let's hear you, if it's possible.
Yeah, I think it should be better now.
Okay, great. Yeah, so you can go ahead now.
Okay, thank you very much. My name is Ajibola Hamzat. I'm the co-publisher at Wiki Times Nigeria. Wiki Time is a newspaper, a digital newspaper based in the northern side of Nigeria. We decided to launch a Wiki Times when we saw the gap in the accountability reporting in that region of the country. The southern, you have quite a number of platforms that are doing accountability, investigative journalism, but you didn't see much of that in the northern Nigeria. And that was a gap that we tried to fill by setting up a Wiki Time. So it was set up in 2018. And between 2018 and now, we've done quite a number of stories holding the governors and different agencies of the government to account. And as Seth also said, within that period of time, we have also collected several enemies who have gone after us. As I speak to you now, we have about 9 cases in court, and we just got one kicked out recently. And maybe I should speak about that particular one because it's a very interesting case of one Saudi Arabia. Sorry, let me set up an eye clinic in Nigeria. It's supposed to be a charity eye clinic as they promoted, and I think they were getting some support funding from different other places. So their charges were supposed to be moderate, but over a period of time, the charges from patients is even much double the one that is found in the private hospitals. But not only that, these fellows were not even their staffs were not paying any tax to the government in any way. They have staffs from Pakistan and other country in the Eastern Asia, and they were not paying taxes. Rather, only the local staff that were paid local, marginal salaries were paying taxes. And lastly, the harassment of the patients and their staff, the staff who complain about the way some of the senior doctors harassed or talk down, shout at the patients and all that. Those of us who complain about it were also treated badly. Some of them were kicked out. So we saw people complaining about the practices of this particular hospital, and we investigated them, and we found all those accusations to be true. And when we spoke to the hospital itself, the management confirmed that yes, their staff that was known for harassing and shouting down on patients and staff has been sent somewhere else. That was the explanation they gave to us. And with regards to the evasion of tax, they said that hey, they're already having conversation with the government about that, and that will be sorted out. So they did not deny that for years that they tried to be evasive, paying taxes. So those stories were published, but not long after we got a brief from their lawyer saying that we're being sued for defamations of characters of their management and the hospital and all that. So we're very glad that after four years of being in court, because they were asking $2.8 million. If you put everything and all of us who work in Wiki Times together, we will not be able to pay that in 50 years. But that's what they were asking us to pay. In a Nigerian exchange today, that's to be around 3-point-something billion naira. They're asking us to pay. So we stay one day, they appear in court. So let's say that we eventually had a good day in court, and the court asked them to, surprisingly asked them to pay 40,000 naira, which is less than $50 as the damages for taking us through that legal route. So what that means in concrete terms is that the hospital knew they didn't have any case in the first place. They just wanted to stress and overwhelm the staff and the resources of our small newsrooms. And also, they were also sending a number of threats to the reporters and our publisher, Haruna Mohammed. For several months, Haruna has to escape Bauchi to other places and later to Ghana. I believe that West African Media Foundation also helped us in some of the litigations, and including the MRA, which Mr. Ediaton, who is a well-respected media person in Nigeria, also helped. So that is for the Halbasa International Foundation, the owner of the Mecca Eye Clinic. The other story was the story we published involving one of the leading politicians in the country. In fact, it was the Speaker of the House. And as the Speaker of the House, he was entitled to get some constituency allowance to develop a number of things in his constituency, the schools, health facilities, and all that. So about $1 billion was allocated to his constituency, and he is the one who oversee how the company who is going to execute our contract. And it's a practice in Nigeria that all lawmakers are expected to have constituency projects, which they get allocation for. But this particular politician, his name is Dogara, because I can mention it because we have already published him, and the matter is in court now. Most of the public projects that he enlisted as to be the project that the money will take care of, some of them are non-existent. And those ones that are existent, no reform or renovations has happened to any of those projects in his constituency. So journalists went around different local government areas in his constituency to see whether those projects were delivered, and many of them were not delivered. And again, we reported it, but it's unknown to many of them in that part of the country that journalists should be holding them to account. What they are used to is to reporters just reporting about their public statements and reporting the events that they organize, but not to expose or ask them questions about how they are using public funding. So it was very, he found it very disappointing, and he sent several threats to us. When we didn't budge, then he sent his lawyers after us and asked us to retract the story. And we insisted we are not going to, we stand by her story. So eventually, he also took us to court and is asking for 2 billion naira. Again, you put every aspect of the Wiki Times together, we might not be able to get that in the next long years. So those are the cases of people and politicians and private companies that we have. As I speak to you, 6 of those other cases are in court, except the one that we have won. The rest are still in court. And as Seth said, this kind of behavior really frustrates the newsroom. It upsets everything. It psychologically affects our reporters, and we have to, every time we have to appear in court, to think of how to raise enough funding to give to our lawyers, and to also send our reporters who are going to witness. And most of the time, some of these the lawyers or their clients might not even show up in court. Some will take us to places far away from where the events actually happen. You can imagine when you are reporting about an issue in northern Nigeria, Bauchi, and somebody is asking you to come to Lagos to come and appear in court. So you have to pay for flights, you have to pay for your lawyers and the journalists who are going to be there. So all these kind of manipulative practices by politicians and business community that we report about is leaving a toll on journalism and journalists in Nigeria. But you still give for not having them coming after you, killing you, because in the past it used to be that you can just disappear very quickly, or you can just get someone that attacks you on the road. There are a number of journalists who have been killed for doing that kind of story. So I think things are still getting better. If they are considering the court option, I think it's still a positive thing to do. But it's something that we also need to contend with, because it has a way of actually doing a long battle against newsroom for a very long time. I'll stop here. Thank you.
Thank you very much. Thank you, Mr. Ansat, for sharing these lived experiences. 4 years in court. You talked about the travel costs. I mean, if within the 4 years you have to be visiting the court, even if it's every quarter for 4 years, and then the issue of damages at one point is 2 million, and at another point 2 billion naira. And I like the part you did mention about the hospital knowing that they didn't have a case, but for in Ghana, we say for shege reasons. I mean, like knowing that they really do not have a case. If Monsieur Loa is here, I think unfortunately his line is a bit unstable, so he's dropped off again. So let me, at this point, thank you. At least we've had a fair idea of the lived experiences of journalists and newsrooms. We're hoping to get the activist side, but I'm sure as and when he's able to get a stable connection, he'll be able to share those with us. So let's, at this point, move to the speakers we also have. First, we are going to hear from Lawyer Gloria Ballison. I think I've introduced her already. She's a columnist herself and a freedom of expression advocate. And she's going to take us through the topic, when the law becomes a weapon against expression and activism. Her session is looking at the issue of SLAPs, that strategic lawsuits against public participation, issues of defamation and other vague legalese that are used and exploited against expression and activism across Africa. I think you have briefly talked about or mentioned the chilling effects of legal harassment. Should touch on that too, and as much as possible, how we can mitigate these risks. So at this point, I would hand the mic over to Lawyer Ballison, so that she takes us through that session.
Thank you, Dora, and thank you everyone for the privilege of having me. I just want to take this minute for us to honor our fallen hero and our friend, Mohib Said, who went ahead of us on the 30th of March, 2025. I think it's important that we acknowledge his contribution to this work, we extend heartfelt condolences to his family and to his colleagues, who we are by extension, and we hope that his profound soul rests in peace. So it's a privilege to join in this conversation on strategic lawsuits against public participation. And I think it's germane that we are having this conversation because it's across the region. To be able to hear the experiences of people tells us that Africa is indeed a village. We may have different experiences of it, but it ends up as one profound issue that happens every now and again in our various jurisdictions. So in a manner of speaking, we may have come from different ships, but we're in the same boat. Strategic lawsuits against public participation are suits that are often filed by public officers, sometimes politicians. They weaponize the court and the legal system to try to see what they can do to overall, to harass activists and people who active citizens and those who are participating in civics, to try to see how they can intimidate them. So idea about these cases is not for justice, it is to intimidate. So part of this is the couching of these matters. So when an activist or civil society are exposing corruption, their response to it is a defamation suit. When there is a protest of, say, illegal mining or illegal activities, their response to it is that it is public disturbance. So you have the Public Order Act that is found in many jurisdictions. When a whistleblower reveals fraud, is that it is a violation of confidentiality. When politicians, NGOs, or civil society decide to do their work, you then find that these government officials and these politicians do a whole lot of work to ensure that they bring active voices the person could be in prison. So they would say that they have kept the person in lawful custody, but really you're serving the time for a crime that you have not done. So these are some of the challenges that there are. Now, SLAP as a concept, that strategic lawsuits against public participation, the coinage of the word began in the USA in the early 1980s. And so far in the USA, there are about 30 anti-SLAP laws. In Canada, I think there are 2 jurisdictions, particularly Ontario and British Columbia, that have anti-SLAP laws. In many of our jurisdictions in the West African region, we may have those kind of safeguards in laws and guardrails against this kind of strategic lawsuits against public participation, but they may not be coined in those very words. So what are the demerits of SLAP? It discourages free speech, it suppresses dissent, and it subjugates alternative voices. It distracts from credible legal matters. If there is a credible matter to engage in, what happens is that they tilt the matter to its head. So those who should be the should be the ones being prosecuted are the ones who turn around to be the persecutors. It also empowers the powerful and weakens civic dissent. It tilts democracy on its head because without dialogue, we cannot claim to have democracy. And then without protest, the issue of accountability becomes challenging. Yeah. For many jurisdictions and in many of our countries right now, government officials and politicians just are unable to hear alternative voices. They believe that they should be the people who are speaking, and the rest of us should say yes, sir, and yes, ma'am. But in the reality of what democracy is about having everybody around the table to engage the issues. So how do we combat SLAP? For the USA and Canada, they have anti-SLAP laws. These laws are very clear about how that you cannot weaponize the legal system against credible issues that have been brought by civic activists, whether they are lawyers, public interest litigation lawyers, or just people who want to participate in what is happening in the country. But where there are no anti-SLAP laws, the doctrine of abuse of court process can be put in motion. The abuse of court process is where cases that ought not to go to court are just taken to court just for the sake of it. So that in itself, it attracts sanctions, legal sanctions, which could include fines. There are remedies in civil law. So when a legal process is used maliciously other than the ends of justice, activists can go to court and seek to ensure that these cases are taken out of court and that there are sanctions for it. Then the use of judicial precedents are also important to dismiss frivolous lawsuits. The court can look back at issues that have happened because, interestingly, there is nothing new under the sun. Everything keeps turning back on its own event. So we tend to live on an orbit that continues to circulate and come back again. So these judicial precedents are very helpful in terms of ensuring that we combat SLAP, that's strategic lawsuits against public participation. But I'm very interested in how activists can protect themselves, because this convening is about activists. What can we do to protect ourselves? This is very important because for many people, those who are in this conversation are their freedom fighters. But for those who use SLAP, those who are the freedom fighters are who they consider terrorists. So in a manner of speaking, we can be people's freedom fighters, but as far as the government is concerned, we could be labeled terrorists. In that case now, we have to look for how to protect ourselves. And the first protection, the first guardrail, the first safeguard is truth-telling. Truth-telling. What are the facts? What are the hardcore facts? It's important that we don't just sensationalize issues or just pick things from the whims and caprices of the streets, but that we're able to gather hardcore facts. We spend the time and we invest in ensuring that we have truth. Truth is the most powerful weapon. And no matter how long a lie goes, the truth catches up with it. So truth telling is very important. As it is often said, you shall know the truth, and the truth shall set you free. The second is that it's important to be the change you want to see. You know, you open yourself, or we open ourselves to the kind of unhelpful criticism if there are parts of our lives or our advocacy that falls short of the glory of what we ourselves are advocating. So, for instance, you cannot go about on a corruption matter if you yourself have been corrupt one way or the other, or if you have been corrupted in a manner of either, even if it is, so if you're a journalist, if you've received money to do the work, to do the investigation, even if the investigation is correct and credible, the process will invalidate the outcome. So you have to be the change you want to be. And that's why activists and civil society people, those who work in that sector, we have to, like Caesar's wife, be above board. Then gather your facts, gather your full facts. If you only have half the facts may be true, the half facts you have, but because they don't give a full picture, you again expose yourself to unhelpful attacks. So have your full facts, be well aware of what it is that you are advocating about, or that you're writing about, or that you're whistleblowing about. Then have a legal team ready for eventualities, as well as sureties for bail. Unfortunately, no matter how many safeguards we put in place, you may not be able to escape the activities of the shenanigans of SLAP, because they have the resources. Typically, they have more resources than the people who are doing the good job, because the sources of their funding, they are diverse, as illegal and as well as illegal. And so that's why it's important that you have a legal team that is on the standby for you. This is where we want to applaud the great work that Media League Defense is doing across the region, because it's doing a whole lot of work. And we also applaud those who are providing pro bono service to activists and journalists who undergo threats. So have your legal team as a backup, and also have ready sureties, so that if bail needs to be taken, you already have the sureties who can present themselves, so you don't necessarily have to be taken to be detained. Then advocate not only for or at the people, but with the people. Do not advocate just for or at the people, but with the people. Advocating with the people is creating an organic movement. People know what the issues are, but typically they are looking for someone who will be the rallying factor for them to be able to then articulate these issues. There is power in numbers, and a lone voice is easier to shoot down. But when there is a choir of voices, it will be difficult to target at anybody, for the purpose of taking the person down without credible and firm resistance. So it's important to advocate with the people. And so we have to do a lot of groundswell work of creating consensus over issues, so that we will be able to break down the power of those who use SLAP to intimidate. The other matter is tied closely to it. Don't just agonize, organize. For many activists, you'll find that in these days of social media, they will talk and talk and talk about the issues. Okay, but what are you doing about it? It's not just important for you to agonize. Everybody knows what the problem is. But the real magic bullet is in finding solutions to the problem. So organize. And my recommendation for proper organization that stands the test of time is to do it ground up. So from the ground level, what is the most basic level to begin this conversation and organization? From those who are the vendors on the streets, to market women, to the drivers, to those who run the bikes. Those are the people who are road transport workers. Those are the people who you want to get them up on board on the issues that you're dealing with so that we can have proper organization. Now, the other part that I want us to look at is how to fight. How do we fight? Because the issues I've just spoken about is how we defend. That is defense. But now, what is the attack strategy? In this, I'm going to just give an example of the work that we do here at House of Justice, where I have the privilege to lead the team. House of Justice is a private public law conglomerate in Nigeria. We have 3 offices in Abuja, Nigeria, in Kaduna, and recently we opened another one in Plateau State. But in the last dispensation in Kaduna, where we have our headquarters, we had some of our clients who were the defenders who were defending they were the activists. And our job became the task, the onerous task of defending the defenders. So we had the case of Aldumekori, who was taken up by the governor at the time, Governor Nasser Ahmed El-Rufai. And he had gotten him locked up, procured the police to pick him up from Lagos, Nigeria, and they brought him to Abuja, detained him there, brought him to Kaduna and detained him there. And we knew that if we had filed a matter in Kaduna, that the governor, because of how relentless he is, he was going to overreach the courts. The first thing we did was we went to Abuja, which was a more neutral ground, and we filed the case. And by the time that we were done with the case, we were able to win the case, and he went on appeal and we won as well. It was the same thing also for another client, Stephen Kefas, who is an activist, who he ensured was picked up from Port Harcourt. Now, this, just to give a sense to those who are not Nigerians, this is about an hour-plus flight from where they are. So this is several miles away from where they were being arrested and taken to. And again, we went to defend them. Now, understand that defending the defenders is a serious issue, because once they can silence those who are defending the public, it's as good as game over. But I think for me, the most serious case that I've had to deal with is the case of the pursuit of the former chairman of the National Human Rights Commission, who is not just a very vocal voice in Africa, but around the world, Professor Chidi Ansem Odinkalu. In that case, what happened was the governor had procured the magistrate court to start a case, and they had arranged to go and pick him up and lock him up. And I happened, again, this is why I spoke about the need to do the work with the public. So I happened to have been at a burial when somebody took me aside and said, look, this is what is being done. They had gotten a magistrate and the paperwork had been done. So what happened was a case was opened. There was no case number, but there was order, and they had already issued an order to pick him up, to arrest him, to lock him up. And so what we did was to now go to that court, applied for the file, and we got somebody behind the doors who brought out the file. We photocopied, and then we appeared before the court to their shock. After that, of course, the magistrate who had the bidding went ahead to continue with the case, even when the case was not on the record, no file number, nothing. He was just given directives by the governor on what to do. So the next thing we did was to file for judicial review at the High Court. But beyond that, we petitioned that magistrate. We petitioned him to the American Bar Association, to the International Council of Jurists. We petitioned him to the National Human Rights Commission. We petitioned him to the National Judicial Council, everywhere that it was possible. And this was someone who had been penciled to move to the High Court. He was in such pressure, he had to abandon the work of the magistracy, and he left. Now, I am taking the time to explain this because, you see, we cannot come to this work lily-livered. We have to be able to stack up our spine and be able to put in as much work, indeed, much more work, than those who are working hard to destroy democracy and participatory governance. But other than that, aside from that, we also filed for the enforcement of the fundamental rights of Professor Dinkalu, and we didn't stop there. We ensured that we deplatform him. The Nigerian Bar Association had penciled this governor who has a long-term plan to be president. They had penciled him on a speaking engagement. We rallied lawyers to ensure that he was deplatformed and he was not allowed to speak. And for him, that was a huge matter. But we did not stop there. When it was time for him to be appointed as minister, and they had penciled him and he had already gone to, so this was now minister of the Federal Republic of Nigeria when he was done with his term, as his 8-year term as governor. I was in my office when they were interviewing him, and while they were interviewing him, the senators from my state had given him a clean bill. One other senator from another state, had raised an objection. Immediately, I picked my phone and called the senator representing my area, and I said, I can't understand that you are in the opposition, because all of the senators are in the opposition party to that same person, and yet all of you gave him a clean bill. And they explained that, oh, it was a strategy. I said, no, but this strategy is not working. So they decided, well, we could put in our objection in House of Justice. That was what we needed. Because at House of Justice, we had the challenge of 8 years of doing many of those cases pro bono for many people who he had violated their rights wholesale. So what we did was to file a petition to the National Security Advisor, and we filed it along with an affidavit. Our job was so clean and clinical. It was as though we were doing a filing before the Supreme Court, but we were serious. We weren't just going to value the process more than the outcome. We were clear that this was not a person who was fit and proper to take any leadership role in the public. Indeed, prior to that, the Senate of Nigeria had already declared that he was not fit and proper to lead in public office. Yet, he still had the opportunity to be governor. But he also had a damning report from the United Kingdom on his violation of freedom of religious rights. So we chronicled all the issues. We didn't just chronicle it, we attached evidence, hardcore evidence, the one that was in the public domain. We put the links, we printed out the facts of the story, we attached it, and we sent it there. And it was what was needed, because there were also people who were not interested in having him there. But that petition became the winning changer, and it stopped him from getting to that position. Now, this is why I would say that it's important that we document issues and violations that are going on. Don't just be haphazard in what you're doing. Document it credibly, document it by ensuring that media reports violations, so that when the time comes, you put together everything and then you get it ready for use. Then the other issue is, do not proceed from a place of malice or smear campaign. No, it's not important. You have to be dispassionate about this thing. So for me, as a person, you know, lawyer. and I had to file my own responses. It was hectic. But in all of that, it was important to me that I retain the core. Because you see, some of these people, what they want to do is to destroy the credibility of who you are as a person. And we cannot afford to lose the core and the essence of why we're doing what we're doing. It cannot be a smear campaign. It cannot be something to proceed with maliciously. Then there's also a need for us to continue to expand cross-jurisdictional networks. What happens in the Smiling Coast of Gambia should matter to the people in Nigeria. What happens in Cameroon should matter to the people in Ghana. We need to really hold ourselves together as a continent and even as a region, because many times the people in our country, they may not care so much about the internal resistance, but once they begin to lose credibility in the eye of other countries, then they get worried. And this is why we must continue to now put in the work of ensuring that we build networks, credible networks. Aside from building credible networks, we do credible work. I want us to elevate the effort with which we're doing our work, that it should be such great work that when it is tested fully equipped, so that when these challenges come against us, we'll be able to withstand the pressure of time. The last thing I'm going to say is, in this work, there is a need for self-preservation. And self-preservation means that you take the basic security checks that are important. You are in limited supply. So we're not going to have, it's not like we have an original copy of you and we're dealing with your photocopy. No, this is just you. And you matter to us. There's something that we will be losing if you're not here. Okay, I spoke about Muhid and Said, who died, but of course his own was, we were told it was sickness. But there are some of our colleagues who have been killed in the line of fire. Maybe some of them died who did not have to die, but some of them natural causes. But we're having this conversation because we want to ensure that we increase in critical mass and that this limited supply that we have of one another is not lost. So let us hold ourselves accountable, look out for our personal safety. Remember that we have families at home that we owe a duty of care to, and that this world needs us beyond what we think or imagine. So I'm going to just, put the stop here and wait for questions. But I really wish you well. And on behalf of all the people of Goodwill, I thank you for the great job that you're doing. And I pray that the Almighty blesses us with good health, with great networks, and with all that we need to continue to do the great job. Thank you very much.
Thank you so much, Gloria. We also pray for all that you have prayed for us that comes to you. And we appreciate your being here this morning because I mean, from the back-end conversations, you've not been well. So for taking the time to go through all, we really, really appreciate it. And we thank you for the salient points that you have highlighted. There are so many. I think I wouldn't want to talk much. Maybe let me just open the space for questions and answers and any comments. Would take some questions and answers, and then we'll take the last two speakers, and then we'll have another question and answer session for that. So for the submissions made by Ajibola, Seth, and also for Gloria, if you have any question, kindly raise your hand, or you can put your questions in the Q&A session so that we try to respond to them. As you think through your questions and your comments, let me just briefly also highlight some of the things that I picked from Gloria's submission. That usually legal harassment, particularly in the form of slap, are not aimed at seeking justice, but just to punish, to frustrate. And it often happens that the culpable people who have to be prosecuted end up rather being those who are prosecuting those of us speaking truth to power, advocating for freedoms and civic expression and all that. So she's also highlighted a number of safeguards that we can use to protect us. And I think just before we started the session, we're actually playing a video on how to avoid defamation. And one of the speakers was talking about number 1 being truth, number 2 being truth, in fact, number 5 being truth. And Gloria has highlighted that as well. I'll pause here because I see a hand up. I'll take the question, we get an answer, and then I'll come back to this in some of the safeguards that she shared with us. So I'll go to Noah Nash. Noah, please unmute and
Okay.
Go ahead with your question.
Okay, so thank you very much for this wonderful
briefly.
presentation. My question is straightforward. I've had a colleague of mine, I work with GH1 in Ghana. So I had a colleague of mine, Banahene, been assaulted recently in one of the electoral activities. My question to lawyer is that, lawyer, you said we should document so that it makes the petition solid. I want to know from you, as a legal person, what exactly are you talking about when it comes to document? Is it that when we publish stories about the event, the legal activities that went on, or when the person goes to write a police statement, is that what you are claiming for us to document? Because some of these things are things that we don't have copies of. So I just want to know what exactly is it referring to as document, please.
Okay, thank you. Let me take the 2 other hands, and then she can speak to those, or I mean the other speakers who have spoken. Okay, forgive me if I don't pronounce your name well, but Ballet or Ballet, please go ahead and unmute yourself and then make your submission.
Bonjour. Bonjour à tous. Vous m'entendez?
Oui. Yes, we can hear you. Please go ahead.
Vous m'entendez? Je ne vous entends pas. Ah, d'accord. Merci.
Oui.
Merci beaucoup. Donc, je suis Pulchérie Balé, activiste en Côte d'Ivoire. Je n'ai pas de questions, mais je voulais vraiment remercier la sœur Gloria pour son exposé parce qu'elle a dit beaucoup de choses qui témoignent de son expérience et que nous vivons aussi au quotidien chez nous ici. Donc, pour ne pas perdre beaucoup de temps, c'est vraiment pour saluer son exposé. Et puis, bon, après, si on a l'occasion de rendre des témoignages, on le fera. Merci beaucoup.
Thank you. Thank you very much. I go to Jane. Jane, please go ahead and make your submission. Moro Dujane. Hello, can you hear me? Okay. Okay, I see you have unmuted, so please go ahead and make your submission. Okay, I'll move on since I'm not hearing anything from Janet, and allow Meshach Odoi to make his submission. Hello, can you hear me? Meshach, if you can hear me, kindly unmute and then go ahead with your submission. Okay, I don't know. It appears there's a bit of a challenge somewhere. So I'll move on to Henry. Henry Shivanga, I hope I got your name right. Kindly unmute and make your submission. But if you are also having a challenge in making your submission, you can actually put your questions on the Q&A and then we'll take it from there. So I would attempt.
Hello, Dora.
Okay, great.
Hello.
So we can pick Morodu, Jane, and then maybe Henry after that, and one more, then we would go for responses.
Hello, Dora.
Hello, please go ahead.
Thank you. So my first question will go to the first speaker regarding the number of lawsuits his institution received within 4 years. So I want to ask him what impacts those lawsuits posed against journalists working in that institution. And my second question will go to Gloria. Because we have seen across most African countries, most of the time politicians or government officials will use some of these laws to silence dissent. What can journalists and activists do to be able to fully protect themselves, especially when they are uncovering corruption and wrongdoing within our government institutions? Thank you.
Hello, can I come in?
Sorry, go ahead. Sorry, I was muted.
Oh, thank you very much. And I want to thank Gloria for her presentation. And I have a question which bothers me a bit. In her work and her experience, does social status play a role when the powerful use slap? What I'm trying to get is, when you are defending the human rights activists, suppose that activist is someone with a better status in society, do they come to such people? Or they hit on someone who is of a low status, or even economically, those people are not well up economically. We fight for the rights of persons with disabilities back in Zimbabwe. And I was arrested for a solo demonstration wherein we were alerting people on the rights of persons with disabilities. Now, I wanted to check, when they suppress such people and you defend them, the demography, are these people whom you defend, do they have a high status in the society, or they are of low status? I don't know whether I have put that question clearly there. Thank you very much.
Thank you too very much. So I think we'll pause. We have 4 questions, and Gloria and Seth would have to speak to them. I'll give the mic first to Gloria and then to Seth. I think Seth talked about the impact, but since it's been asked, he can briefly rehash them. And then for Gloria, the issue about documentation, safeguarding ourselves as journalists, as activists, and also the issue of social status and SLAP. So please take over. Thank you.
Thank you for your kind interest. So what do you document in writing stories? Please document everything. proceed with every story with the thought of what's the worst case scenario. Just imagine that something would go wrong for any story that you're doing. And when that thing goes wrong, what will you require as hardcore evidence? Record everything, have everything, every bit of whatever it is, even when you think is relevant or not relevant. Please document every and anything, because you never really know what evidence will come in handy. The second one is, what safeguards do you have for covering stories? The number one safeguard, like we said, is truth. Protections in terms of work in the field, you take basic precautions, the precautions that are necessary for those stories. If you know that an information is sensitive, you don't just go putting yourself in the line of fire. It will be like you are standing, right in front of a moving train. But there is a way that you can stop the evil that is happening in that train without necessarily standing right in the track and trying to wave the train down with your own hands. So take basic precautions. Now, let me also say this part. Sometimes as activists, we have the Elijah mentality, where we think that we're the only one. I use this just as a metaphor. We feel that we're the only ones who are doing the work, and that anybody in public service is either a corrupt person or about to be corrupted. The truth is, the great part of human nature is found everywhere, just as the corrupt part. And so we must open our eyes to look for the alliances everywhere. Even in writing your story in a corrupt organization, you may still find people there who are willing to help you, who are willing to aid you with your story, who are willing to give you information without you putting yourself at risk. They will take those risks for you. But you have to have earned their credibility. And that's why I spoke about the need to be credible in your work and in your person. Be someone whose life and whose work command respect. That's important. Then my friend from Zimbabwe who spoke about whether status plays a role when the slap is used. So do they come wanting to just skim you off of everything? Well, in my own practice, I've had people of different status whose slap has been slapped against, pun intended. Aldo Mekori, for instance, is a leading chocolate, is a leading record label a person in the whole of Africa, Chocolate City. And he's also a lawyer, but he's also an activist as well. So in terms of his financial capacity, he's not a poor person, but they proceeded against him. Professor Chidi Anse-Modinkalu is by no means a poor person. And in terms of if they can proceed with a slap suit against someone who is a former chairman of the National Human Rights Commission, you know that that is serious. And we understood how dampening that would have been. So we went extra mile to do a whole lot of work to ensure that nobody tries it again. So there is the one that you go over and beyond, because you want to, as much as they want to make a statement, you also want to make a clear statement that this is how far you can go and no more. So to answer your question, it can be people of different suits. But of course, as you know, it's always easier to punch at those who are the low-hanging fruits, if you want to put it that way, because they want to just skim you off of whatever you have. That's always been the thing, to prey on the weak. So either way, I also think that those of us who are in the civil society realm should also think very clearly about what being rich means. No one should be so rich that all that they have is money. Yeah.
Thank you.
Because
Thank
in
you,
my own
Glory.
line of work, the thing that has really helped is to be able to have the currency that you cannot deplete very easily is the currency of goodwill. And that's what we must really work hard to have. Goodwill, credible goodwill. Thank you very much.
Thank you. Thank you. Seth, could you just, in about 30 seconds, just try to answer the bit about impact of the lawsuit on your work so we can move on? Thank you.
Okay. Apart from thank you, Dora. Apart from the financial strain on the organization, I also mentioned the psychological impacts on journalists. Being bold in a newsroom is different from, facing a judge in a courtroom, and the kind of anxiety and fear you have in defending your work. Your work may be good, but when you are facing a judge, it's a different story altogether. And also the reputational impacts. I mean, you have done a very good job. That job has saved the government billions of cedis or millions of cedis. But then you also face public judgments because you have been sued. For all you know, the person is seeing you as doing wrong because you've been sued. It may not necessarily mean that you have done anything wrong, but you've been sued. That affects your image out there. And for a journalist, our major currency is credibility, as Gloria said. If you don't have credibility, if you don't have goodwill, your work is cost 90. There's no value in it. People would not trust the brand. So it affects your brand as well. And there's also the chilling effect in the newsroom. You begin to be cautious about which stories to do and which stories not to do. And ultimately, self-censorship sets in. But in our case, we have a very strong backbone in the media, in the name of the Media Foundation for West Africa, and lawyers who are able to vet our stories and say, this is good, this is not good enough. Can you verify this enough? Can you produce evidence to support it so that in case we go to court, you are safe? Yeah.
Thank you, Seth. I like the bit about the backbone, and we are happy that we are able to support not just the Fourth Estate, but also journalists and activists across West Africa. I'll talk about that in a bit, but in the interest of time, I'm going to ask, I see 3 hands up and they are all Meshach Odoi. If you could just rename so that it's easier. When I say Meshach Odoi, you know who it is I'm referring to, then it will be easier. So kindly rename so that we'll be able to take your questions. And also, like I said, just in the interest of time, we would want to move on to the next presentation. So kindly put your questions in the Q&A, and Seth, Ajibola, and Gloria, kindly check the Q&A. There are questions there, and I believe you can provide direct responses to them. So if you are unable to put your questions there and you still want to raise your hand, just hold on. Let's take the last 2 presentations, and then we can take the rest of the questions. I believe we are together on this. So thank you. And so let me, at this point, invite our next speaker. As I mentioned, he's from Côte d'Ivoire, Dr. Dr. Dogboime Kone, a distinguished lawyer from Côte d'Ivoire, and he's going to take us through legal protections and regional mechanisms. And one of the questions asked about the possible and available mechanisms or redress pathways available. So, Dr. I'm tempted to say Monsieur, Dr. Dogbeme is going to take us through that. At this point, I hand over the mic to him. Hello. Dr. Kone, can you please hear me?
Is it on?
Dr. Kone, I see your mic is unmuted. So if we could see you and then hear you, that would be great. Thank you. I think we are having a little challenge in terms of the sound from Dr. Kone. Dr. Kone, I don't know if you have enabled the microphone on your device. If it hasn't been done, kindly check and do that. So whilst he sorts that one out, I would want him to do the mechanisms, and then the next speaker, Mr. Edetine Ojo, would handle the regional resilience and then regional solidarity and related issues. So it will be good if we hear Dr. Kone before him. So whilst he sorts the sound out, I would just want to remind distinguished speakers and frontliners that please check the Q&A and please provide the answers directly to the questions that have been asked there. Thank you. And Dr. Kone, can you please just probably drop off and then rejoin? Let's see if it will work. Maybe that should work. So whilst he does that, let me again just share or reiterate some of the points that Gloria made on how we can safeguard or fight legal harassment. Ensure that at all points you are truthful and you remain truthful. Have the full facts at all time, and ensure there's documentation so you can use it as evidence. Hello, Dr. Kone. Okay, we'll give it about 1 or 2 minutes, try again, and then we'll see. And then have a legal team on hand. And that is so key and so important. I think Seth talked about it. And we at the Media Foundation for West Africa are also very happy that we set up the West Africa network of activists and media defense lawyers, of which Gloria and Dr. Kone are part. The acronym is simply WANAMDEL. If you are on this call or you have a colleague who at any point in time needs legal advice or some form of legal assistance in handling a case or making progress with it, you can reach out to us at Media Foundation and we'll link you to one of these esteemed lawyers who can help you and guide you in the process. And then she talked about having to mobilize from the grassroots and don't just advocate for and at people, but also with people, because they would help you make a case. Hard work, don't start on a note of malice, and also the need for cross-border network and credible work, security checks. She talked about a lot of things. So I hope I've been able to capture as many of them as possible. Let's try if we can hear Dr. Kone, and then we'll move on from there. Hello, Dr. Kone, can you please hear me? Okay, maybe we'll come back to him. At this point, I would want to invite the Executive Director of Media Rights Agenda, Mr. Edetine Ojo, to make his submission about how to build resilience and how to build regional solidarity so that when we encounter some of these legal challenges, we are able to withstand, we are able to go through to ensure that, like Seth said, we don't end up being censored, but we'll work together and ensure that we demand accountability from authorities. So, Mr. Ojo, please take the mic. Thank you.
Thank you very much, Dora. Can you hear me?
Loud and clear. Thank you.
Okay, thank you. Good afternoon from Nigeria, colleagues. So as Dora has announced, I have been asked to talk to you about building resilience and regional solidarity, which Gloria has also very generously touched on in her presentation. So I think that some of the things she said are aligned with my own suggestions, but I'll try and avoid too much repetition. So just to provide a context, which I think has also been adequately articulated in the course of this webinar. Usually the objective of SLAPS is to intimidate, is to exhaust and silence critics, and much less an effort or a legitimate desire to obtain legal relief. So obviously this is an obstruction of public interest journalism and other kinds of public interest activism. So even if a case is ultimately dismissed, the time, the expenses, the reputational damage, and the sheer emotional toll that such a case exerts on journalists and media organizations as well as activists can really deter people from engaging further with these issues. I think we've heard that from our colleagues who have shared their lived experiences, although we have different levels of tenacity and courage, and some people carry on, but your average person will probably decide that they would rather do something else than live this kind of life. So how do we build an effective response that blunts or mitigates these very insidious tools that powerful people and rich people frequently use to try and silence their critics? I do not believe that a single approach will sufficiently push back on this issue. So we have to develop a multi-pronged strategy with different elements, and I'll just share some of my thoughts on the different elements I think would be part of that broad-based strategy. One of the elements I think should be a really determined effort to embark on legal and policy reforms. I think SLAPS exploit weaknesses in our legal systems to prey on resource-constrained individuals and organizations because given that the legitimate objective is not to get relief, but really to exhaust people and force them into silence, everything is done to draw out cases, to deprive you of resources to continue to defend such cases to the extent that you simply surrender. We therefore need to reform these systems. More specifically, I think we need to embark on advocacy for the adoption of laws, regulations, or policies that will enable effective pushback. The elements of such frameworks would include, for instance, the possibility of seeking early dismissal of suits that are simply aimed at targeting public interest journalism or public participation in governance processes, and shifting responsibility for paying legal expenses in such cases, person who initiated the suit but lost. This is not really a novel idea. Again, as Gloria indicated in her presentation, we've already seen countries in Europe, in other parts of the world like Canada, Australia, and a number of states in the US that are adopting anti-SLAPP laws in an effort to protect freedom of expression. It's not something we've really embarked upon in this region, but perhaps now is the time to begin to look at that and put proposals on the table. Although there are variations in such laws in different countries or in different parts of the world in general, I think that they allow a defendant to file a motion to dismiss a SLAPP suit at a very early stage on the grounds, for instance, that the matter involves protected speech or freedom of expression on a matter of public interest. And that should be something that public policy should really support, that you don't want to stifle public interest journalism. In Nigeria, for instance, part of the responsibility that the media has is to hold government accountable to the people. And when you begin to stifle the ability of the media to do that, then of course you're undermining a major pillar of good governance, which was as part of our constitutional framework. So if the plaintiff's case is dismissed, he or she would then need to bear the legal cost of the defendants, and in some jurisdictions may also be ordered to pay a penalty for bringing the case at all. Other elements of such a framework could include protections for journalists and media outlets that are reporting in good faith on matters of public interest. So they are not unduly sensationalizing stories, and as colleagues have said repeatedly, when the truth of their reporting is strong and can be proven, then it's clear that they are acting in the public interest, and any effort to undermine that should be prevented. These reforms would have to be pursued in individual countries in the region, although I think a regional instrument could also be pursued to serve as a model or guideline for national frameworks. So we can really look to what would be the best approach in terms of a legal framework that can help countries in the region to begin to respond to the reality that we are now facing. But even with such legal reforms, it will still be an enormous challenge for journalists, under-resourced media houses, or activist organizations to go against individuals or corporations with enormous wealth, because they can come at you over and over again, even when their cases are dismissed. For them, money is not really an issue. It's just to exhaust you, and they have the resources to achieve that. So it's important that we do not place journalists, media organizations, and activists in a situation where they want to completely avoid public interest journalism or commenting on activities of such wealthy individuals or organizations, simply because they lack the resources to effectively defend themselves when they are sued. So another element of this building resilience and solidarity would be enabling, instituting processes and mechanisms to provide litigation support and funding for journalists, media houses, and activist organizations that are facing such SLAPP suits. The sort of work that Gloria is already doing, and we have quite a number of lawyers around the region, including the Media Foundations Network, that are providing those sort of services. But we do need a lot of them, because I think we're having an escalation of litigation against media and activists. So such support could include an emergency legal rapid response fund to finance immediate legal defense when SLAPP suits are initiated against media organizations, individual journalists, or activists. And we also know that some of these cases come as criminal prosecutions, where in theory, the defendants are granted bail, but the bail conditions are so onerous that they are unable to meet them, and they end up in remand. Courts would say, oh, we granted them bail, but they are not able to meet the bail conditions. So there needs to be a system in place where such people can be supported. And of course, there would be some other elements, some other expenses that can form part of this emergency fund. Also, as part of this element, I think it would be important to have either a single network or several networks of pro bono lawyers, which can be established and provided with necessary capacity building to defend such cases effectively. The reality is that although we have quite a lot of lawyers in Nigeria and across the region, many of them are not trained, do not have the expertise or the experience to litigate these sorts of cases, do not have comparative international experience about how such cases have been addressed in other jurisdictions. So some capacity building would need to be incorporated into such a network so that, you know, lawyers that donate their time and their expertise would be supported to make them a lot more effective. Again, this strategy, I think, can be explored at the national level, but we could also have regional coordination and experience sharing. I mean, people like Gloria, for instance, who have a lot of experience doing this in specific countries would likely share that experience and insight with colleagues in other countries who may just be getting into that process and don't have much to draw on. And I think through that kind of collaboration, we would strengthen the legal response that would subsequently be seen. Well, whatever approach is adopted, I think this resource could also be in the form of a roster of media and human rights lawyers, either within a given country or similar to what we're hearing that the Media Foundation has, a regional network across West Africa of lawyers who are willing to provide coordinated support. So there are different countries, they can move quickly, but then they receive support either in case law or other forms of support from colleagues in other countries. Again, even with the existence of such a network of lawyers who do not charge legal fees, the support would nonetheless require financing because there are a lot of other expenses apart from legal fees that come with litigation. There are administrative costs, there are operational costs, there are filing costs, there are service costs, transportation expenses, bringing witnesses in some cases. All of this costs money, and we cannot expect lawyers who are already giving their time and expertise to be bearing those expenses. So we need to have some resources to support that kind of process. One obvious solution would be, especially for those of us who have NGO civil society background, is to lean towards donors. However, this is an extremely uncertain approach because donors have policies and considerations which frequently do not align with our priorities. So sometimes we're forced to go with their priorities or do without. So I would say that we need to explore additional possibilities for resourcing these kinds of engagement. One such possibility, for instance, could be security insurance or litigation risk facilities that would provide the resources to underwrite those sort of costs, at least in part, if not wholly. And then we could also have media houses or association of media proprietors who would be encouraged to explore collective insurance schemes for media houses or some form of legal defense cooperatives. All of these are options, and I don't think that they need to be either one or the other. I think they can all work at the same time and really provide adequate resources to make this effective. Another component of the strategy, in my view, would be facilitation of cross-border cooperation and solidarity, which would include having systems in place for timely sharing of alerts regarding SLAPP suits. So once a SLAPP suit is filed in a country, that information is shared through a network that stakeholders and those that are interested immediately become aware of it and can provide support and input as may be within their capacity. Also, alongside that, sharing of updates and outcomes so that we also know cases that are being filed, how are they turning out, what developments are going on, sharing of precedents and defense strategies, quite frankly, because sometimes a case may be filed in one country and the lawyers, have a tunnel vision about how they want to approach it. But those with either more experience or different kinds of expertise can also share defense strategies which may be much more effective than what the in-country lawyers may be thinking. So I think that also having that kind of cross-border collaboration that enables sharing of defense strategies would also be useful, and planning other solidarity actions, whether they are lobbying governments to put pressure on other countries or they are organizing regional protests, taking on various activities to spotlight abusive litigation across the region. All of this would need to be coordinated to some extent. Now, if we are going to be resilient, we also need to engage in some capacity building for ourselves as media organizations and activists to improve our preparedness for the prevailing environment that we are now operating in. A lot of us have little or no understanding of basic issues like libel or defamation law. We don't have a great deal of knowledge or experience about preservation of evidence, how to avoid legal liabilities, and more specifically, how to avoid or respond to litigation. And alongside that, we also need to have better organizational preparedness, including, for instance, having a legal response plan. So organizations like Wiki, Times, and so on that are frequently being sued, do they have a legal response plan so that once a suit comes up, there is a plan in place for responding? Or are you thrown off balance every time a suit comes up because you don't have, an organizational preparedness plan to respond to such situations? Obviously, again, having designated legal focal points or persons in newsrooms and news organizations should also be part of that, strategy. And then appropriate protocols. I mean, a number of colleagues who have spoken here have talked about the importance of documentation, of documenting everything. Do we have appropriate protocols in our organization for documentation, preservation, and archiving of materials that could become evidence? Because once we don't have that practice, that approach, and evidence is suddenly required, even if our stories are true, if we don't give the lawyers materials with which to defend them, then we can't prove the truth of the stories that we've put out. So being African anti-SLAPP convening, where we could possibly have, media professional bodies and unions, media organizations, media NGOs, and other types of human rights NGOs, national bar associations, legal or law-based NGOs, regional bodies like ECOWAS, the West African Bar Association, donors, and so on, in attendance to, really deeply look at these issues and develop a comprehensive strategy. The event could also be used where we are tracking suits can help us as we progress. In the medium term, we could also draft a regional model anti-SLAPP law, which can be adaptable for different national contexts, conduct regional and national level training workshops for journalists and media organizations on how to mitigate their legal risks, while in the longer Sorry, it appeared my connection dropped for a bit. I don't know how long.
Hello, sir.
Hello.
Okay, I think
Can you hear me? It appears
Yeah,
connection
it's like
went
your
off a
connection has
bit.
dropped. Yes.
For how long? Hello?
Hello.
Yes, for how long was I off? Or can you tell me where you last heard me?
It's a bit difficult, but I think the last thing I picked was the need for model anti-SLAPP laws that are adaptable for other countries.
Okay. So it's not a long time ago. So I was saying that following the convening, which I think should be an obvious first step, in the medium term, regional model anti-SLAPP law, which different countries can adapt depending on their context, and then conduct regional and national level training workshops for journalism and media organizations on how to mitigate their legal risks. Because again, many journalists are just basically primarily concerned with, producing journalism, looking for the stories and publishing them, and not thinking of these other issues that are making the job difficult. And then in the longer term, there should be advocacy for the adoption of either anti-SLAPP provisions in existing national laws or comprehensive anti-SLAPP, legislation, which will then make it possible for media organizations, journalists, and activists to respond with some fighting chance to the current legal environment. So I think I'll stop here in the interest of time. Those are some of the proposals I would like to put on the table for building resilience and then solidarity on a regional basis. Thank you.
Thank you so much. Thank you. I think my list, I've picked over 10, if not over 12 points already. Thank you. And like you mentioned, in the interest of time, we would take the presentation from Dr. Kone, and then would come and do the Q&As. So Dr. Kone, kindly take over.
D'accord. Merci beaucoup, Dora. Je pense que ça va maintenant. Vous m'entendez bien?
Oui.
Alors, je vous remercie pour cette invitation. Je remercie Dora, je remercie Media Foundation, le professeur, et puis M. Delali et toute l'équipe. Alors, j'interviens rapidement sur les moyens de l'Afrique de l'Ouest, c'est-à-dire au niveau des juridictions et au niveau des instruments pour la défense du droit des journalistes et des activistes. Alors, rapidement, sur les instruments, je ne dirai pas beaucoup de choses parce que j'aurais beaucoup de choses à dire sur les juridictions. Ce que je veux dire, c'est que la liberté de la presse est consacrée dans presque toutes les constitutions de pays de l'Afrique de l'Ouest. C'est-à-dire que pour les pays de l'Afrique de l'Ouest, les citoyens doivent pouvoir s'exprimer. C'est dans leur constitution et c'est venu de la colonisation. Pour certains pays, c'est venu de la loi française de 1881, de juillet de 1881. Pour d'autres, c'est venu des grands textes anglo-saxons, l'Habeas Corpus, la Magna Carta et autres. Mais surtout pour tous, c'est venu de la Déclaration universelle des droits de l'homme de 1948 de l'ONU, dans cette organisation où presque tous les pays de l'Afrique de l'Ouest se retrouvent. Alors, la grande problématique des droits de l'homme, c'est que les droits de l'homme mettent en face le citoyen et l'État. Et donc, le premier violateur des droits de l'homme, c'est l'État. Et la difficulté, c'est que la souveraineté de l'État est un élément qui fait que l'État a tellement de pouvoir, comme ça a été dit avant moi, et je m'associe à tout ce qui a été dit, l'État a tellement de pouvoir, tellement de puissance, que lorsque nous sommes face à l'État, on a le sentiment qu'on est négligeable, on est petit. Mais le droit, la liberté d'expression est d'abord et avant tout une liberté. Et en tant que liberté, les libertés s'obtiennent par des luttes et des combats. Et le périmètre des libertés va se trouver agrandi chaque fois qu'il y aura des luttes et des combats. Alors, ces luttes et ces combats ont été assez nombreux en Afrique de l'Ouest. Ils ont été menés d'abord par la Cour africaine des droits de l'homme, qui a de grandes faiblesses. Ensuite, par la CEDEAO et par l'UEMOA, la Cour de l'UEMOA. Il est étonnant que je parle de la Cour de l'UEMOA, mais je viendrai pour vous dire 2 ou 3 éléments parce que on va me dire que la CEDEAO est plus avancée effectivement que la Cour de l'UEMOA. Concernant donc la liberté d'expression, on a des grands textes. On a la déclaration des principes de l'Union de la Cour africaine des droits de l'homme. On a la déclaration des principes sur la liberté d'expression et l'accès à l'information en Afrique. On a les textes du traité de la CEDEAO. On a le traité de l'UEMOA, grosso modo. Parce que, comme j'ai dit, le droit de l'homme entre dans l'espace juridique, dans l'ordre juridique africain, Afrique de l'Ouest, mais africain en général, par la colonisation. Donc, ces constitutions déclarent accepter les déclarations qui ont été faites antérieurement, la déclaration de l'homme, des droits de l'homme et du citoyen, etc. Tous ces textes qui ont été faits de plusieurs générations des droits de l'homme, je ne reviendrai pas là-dessus. S'il y a des questions, je pourrais vous répondre. Dans la défense de la liberté de la presse, il est bon effectivement qu'on documente l'article, qu'on documente sa production, qu'on documente la diffusion et qu'on la documente sérieusement, comme l'ont dit mes prédécesseurs. Je voudrais aussi ajouter, il faudrait qu'on la documente juridiquement, dans le sens juridique. Il y a documenté pour respecter les textes, et puis il y a documenté pour s'apprêter à un procès éventuel. Dans le cas des procès éventuels, nous avons la Cour africaine des droits de l'homme qui assure la protection des droits de l'homme et de la liberté d'expression. Elle a cependant des faiblesses. Elle a des faiblesses parce que cette Cour-là, pour que les ONG qui sont plus disposées, mieux outillées pour saisir la Cour, puissent la saisir, et pour que aussi des individus puissent saisir la Cour, les textes de la Cour africaine des droits de l'homme exigent que l'État, d'où émanent ces ONG et ces individus, reconnaissent cette compétence à la Cour. Cette reconnaissance n'est pas simplement le fait qu'elle soit partie au traité qui crée la Cour de rien, non, mais il faut qu'il y ait une acceptation volontaire, il faut un acte qui matérialise cette volonté, et en plus, ils peuvent retirer cette volonté à tout moment. Nous avons le cas du Rwanda, dans l'affaire Ingare Victoire, j'espère que je ne coche pas son nom, excusez-moi. Dans cette affaire, le Rwanda qui avait tenté à un moment donné, lorsqu'elle a vu que la Cour allait statuer, de retirer la compétence à la Cour dans le but de pouvoir, voilà, Ingabire Victoire ou Mooza contre l'État du Rwanda, celle qui avait critiqué le génocide d'une façon ou d'une autre. Toutefois, malgré cette faiblesse de la Cour, malgré aussi le fait que les décisions de la Cour africaine des droits de l'homme ne sont pas revêtus de cette grande autorité qu'on attend des décisions judiciaires, malgré cela, la Cour africaine des droits de l'homme a beaucoup œuvré pour la liberté d'expression au travers des affaires Zongo, que vous connaissez très bien. L'affaire Zongo, ce journaliste qui a été tué avec son frère et 2 de ses collaborateurs, et les juridictions du Burkina Faso ont été saisies pour connaître de cette affaire. Évidemment, elles ont piétiné dans l'examen de cette affaire et la Cour a donc condamné le Burkina Faso pour avoir violé les droits de l'homme, et on s'attendait aussi que la Cour puisse travailler dans le sens des libertés d'expression, dans un sens plus ouvert, mais c'est déjà une avancée et nous prenons ce qui est là et nous essayons de l'améliorer. Nous avons également l'affaire toujours contre le Burkina Faso, de ce journaliste qui a eu, des disputes avec le procureur de la République, voilà, Lo Issa Konaté, contre Burkina Faso, Lo Issa Konaté, il a eu des propos qui ont été qualifiés d'outrageants, c'est-à-dire il a outrage à magistrat. Il y avait un procureur bien qui disait des choses et le journaliste a répondu. Et la Cour africaine des droits de l'homme a considéré que les 1 an d'emprisonnement ferme qui a été décerné contre M. Lo Issa Konaté était trop sévère. Et donc, ils ont ordonné que cette décision n'ait aucun effet et que ce monsieur soit relevé de cette condamnation. Mais ce qui est intéressant dans cette décision par rapport à l'exécution, la réaction de l'État du Burkina, on en parlera. Mais ce qui est très intéressant, c'est le courage d'abord de la Cour. C'est ensuite la motivation. La Cour écrit ceci. Elle dit que pour la Cour, les hommes publics devraient être plus enclins à la critique que les citoyens ordinaires. C'est-à-dire, quand vous êtes magistrat, quand vous êtes procureur, procureur général, procureur de la République, vous devez accepter la critique. Vous devez être ouvert à la critique. Parce que ça fait partie de vos fonctions, du fait que vous êtes déjà sur la place publique, qu'on puisse vous critiquer, ça participe de la transparence de la gestion de la chose publique, ça participe du débat démocratique. Donc, à travers ces 2 affaires-là que je donne par rapport au temps, l'affaire Norbert Zongo, l'affaire Lo Issa Konaté contre l'État du Burkina, et puis la 3e affaire, l'affaire Ingaribe Biré Victoire Oumouossa, qui a écrit un article qui a été jugé comme faisant l'apologie du génocide par le Rwanda, et également injurieux. Elle a saisi la Cour et, comme j'ai dit, l'affaire est intéressante parce que le Rwanda, État parti à la Cour, a donc écrit pour retirer l'acceptation qu'elle avait donnée, parce qu'ils en ont la possibilité, à la Cour de pouvoir recevoir les plaintes des ONG, donc des OSC, des organisations de la société civile, et des individus. Et la Cour a rejeté la demande du Rwanda de façon très courageuse et a maintenu sa compétence, et la Cour a décidé qu'il y avait violation de droit à l'égard de Madame Ingaribire Victoire. Ça, c'est au niveau de la Cour africaine des droits de l'homme. La Cour africaine des droits de l'homme qui a rendu ces 3 grands arrêts qui touchent à la liberté d'expression, de même que le texte phare que j'ai cité, les principes sur la liberté d'expression. Mais il y a aussi une protection en Afrique de l'Ouest. Et la première protection que j'invoque, c'est la protection de l'UEMOA, l'Union monétaire des États d'Afrique, des États de l'Afrique de l'Ouest, qui comprend 8 pays, le Bénin, le Burkina Faso, la Côte d'Ivoire, la Guinée-Bissau, le Mali, le Niger, le Sénégal et le Togo. L'UEMOA, dans l'affaire Eugène contre l'État de Côte d'Ivoire, contre la Commission, c'est vrai qu'il s'agit là du contrôle de l'égalité du droit communautaire. Mais dans ce contrôle de l'égalité du droit communautaire, il y a un droit de l'homme qui est sous-jacent, qui est protégé, qui a été protégé par la Cour de l'UEMOA, dont il faut dire elle a la prédominance du contentieux de la fonction publique UEMOA. Fonction publique. Et donc, dans cette affaire, l'État de Côte d'Ivoire avait nommé une dame qui s'appelle Brogrébé pour remplacer M. Yahi Eugène de façon sans le respect des droits. Et donc, il a saisi la Cour de l'UEMOA et la Cour de l'UEMOA a jugé que c'était illégal sa révocation. Alors, cette décision de l'État de Côte d'Ivoire était un acte additionnel de la conférence des chefs d'État. Donc, ils ont notifié leur décision à la conférence des chefs d'État. La conférence des chefs d'État a pris un 2e acte pour enlever M. Yahi à son poste. Yahi a encore saisi la Cour. La Cour a révoqué ce 2e acte. La conférence encore des chefs d'État a pris encore un 3e acte pour encore révoquer M. Yahi. La Cour a encore révoqué ce troisième acte. On parle d'entêtement de la conférence des chefs d'État. Mais ce qui est intéressant, c'est le courage des juridictions qui ont maintenu la légalité, donc l'ordonnancement juridique de l'UEMOA. Je vous le dis parce qu'on peut penser que l'UEMOA, d'une façon ou d'une autre, n'est pas vraiment lié aux droits de l'homme, et on a raison de le dire, mais il y a des décisions qui arrivent sur les droits de l'homme. Maintenant, je voudrais en arriver, avec votre permission, à la CEDEAO, la Cour de la CEDEAO. La Cour de la CEDEAO a ajouté à ses compétences la protection des droits de l'homme. Et c'est une cour qui est assez intéressante dans ses compétences. Pourquoi? Parce que la Cour africaine des droits de l'homme et des peuples, qui vient de la Charte africaine des droits de l'homme et des peuples, elle ne peut être saisie qu'après l'épuisement des voies de recours internes. Or, la CEDEAO ne fait pas de cette condition une obligation au demandeur à l'action devant la CEDEAO. Celui qui fait l'action en demande devant la CEDEAO n'a pas besoin de rapporter la preuve que dans son pays, il a épuisé toutes les voies de recours. Donc ça, c'est le premier élément qui est important. Le deuxième élément qui est aussi important, c'est que les décisions de la Cour ne peuvent pas faire l'objet d'appel. Donc, la conférence des chefs d'État qui apparemment en position hiérarchique est au-dessus de la Cour parce que ce sont des commissions, des structures créées par les chefs d'État qui créent la Cour et qui créent aussi qui nomment aussi après examen les membres de la Cour. Donc, on est porté à croire que l'indépendance de la Cour peut être entachée. Mais la Cour est indépendante juridiquement et dans ses décisions, elle a fait l'effort également d'indépendance. Et il y a plusieurs affaires comme ça. J'en ai noté 9, mais je vais aller rapidement. La première affaire, c'est une affaire que vous connaissez bien, l'affaire d'Eida Idara Junior et autres contre la Gambie. C'est un journaliste qui a été arrêté de façon arbitraire, qui a été détenu dans des conditions arbitraires, qui a fait l'objet de tortures et qui a été tué. Et ce journaliste, sa famille et les organes et les ONG ont saisi la cour de la CEDEAO. Cette cour peut être saisie par des individus. Et d'ailleurs, la cour, dans ses décisions, dit que la cour n'est compétente que lorsque on est en face d'un État. Donc, c'est des individus face à des États, parce qu'il y a eu des affaires où ils ont individu contre individu, la Cour a estimé qu'elle n'est pas compétente. Donc, il faut un individu contre un État. Un individu contre un État. Et la Cour n'attend pas, comme je l'ai dit, l'épuisement des voies de recours internes. C'est une affaire, donc, qui a commencé à piétiner en Gambie, dans l'examen des demandes, et la Cour a été saisie, et la Cour a rendu une décision, un statut à Abuja. Elle a rendu une décision qui a dit que les articles 1 et 4 de la Charte africaine des droits de l'homme ont été violés. Ceci me permet de souligner quelque chose de très important par rapport à la Cour de la CEDEAO. C'est que c'est une juridiction qui, dans sa base textuelle, c'est-à-dire quels sont les textes qu'elle applique tous les textes qu'elle trouve sur la terre. Elle dit, voilà, tous les textes. Elle a pris des jurisprudences dans l'affaire des jugements de Yougoslavie. Elle s'appuie sur des jurisprudences de l'Union européenne. Elle s'appuie sur des textes, donc des instruments des droits de l'homme de l'Union européenne, de l'Union africaine. En fait, des textes dont, a priori, elle n'est pas la première gardienne. Elle n'est pas la première gardienne, mais dont elle se fait l'interprète et sur lesquels elle se base pour protéger les droits de l'homme. On a parlé dans la littérature doctrinale que la Cour a une compétence étendue, c'est-à-dire une extension de l'objet de la compétence de la Cour. Elle est large et ouverte. Et donc, dans cette affaire, la Cour donc a sanctionné l'État de Gambie. Et dans l'affaire Tif et Brima Mané contre la République du Gambie, cette affaire aussi, le monsieur, c'est un journaliste qui a été arrêté. Il a fait 22 jours au service national d'intelligence. Et la Cour a rendu, c'est une affaire intéressante parce que dans cette affaire, la Gambie a refusé de comparaître. Donc la Cour a fait plusieurs renvois pour que la Gambie puisse se présenter et l'État de Gambie ne s'est pas présenté. Et la Cour a rendu une décision avant dit droit, c'est-à-dire avant de juger qui a raison, qui a tort, elle a rendu une décision pour demander à la Gambie de comparaître. Elle a désigné des personnes, des agents, des fonctionnaires qui étaient impliqués dans le dossier pour qu'ils viennent devant la Cour pour s'exprimer. Ils ne sont pas venus et la Cour a rendu une décision par défaut réputée contradictoire contre l'État de Gambie et donc qui a été condamné. Vous avez, même dans une affaire politique, troisième affaire, l'affaire Mamadou Tandia contre Salou Djibo et État du Niger. Cette affaire, comme je l'ai dit tout à l'heure, je vais rapidement, c'est l'action contre Soulo Djibo a été déclarée irrecevable parce qu'on n'attaque pas un individu, on attaque des États. Et dans cette affaire, Mamadou Tandia, qui était un ancien chef d'État, a été renversé par un coup d'État. Et malade, emprisonné, il a fait plusieurs demandes de libération pour cause de maladie, rejetées par la justice de son pays. Il a fait les voies de recours rejetées toujours par son pays. Et avant même qu'il ne finisse ses procédures, ses avocats ont saisi la cour de la CEDEAO qui a ordonné sa libération immédiate pour qu'il puisse aller se soigner. Donc, vous voyez que la cour de la CEDEAO nous envoie, grâce à l'action qui est menée par les OSC, les ONG, par les individualités, par l'Association des avocats sans frontières, par les journalistes sans frontières, par tout le monde, est en train de faire un travail qui est très, très remarquable et très important. En quatrième affaire, nous avons l'affaire Simone Gbagbo et Michel Gbagbo contre la République de Côte d'Ivoire. Dans cette affaire, euh, euh, la Cour s'est déclarée incompétente sur la demande et l'action de Mme Simone Gbagbo. Pourquoi? Parce que Mme Simone Gbagbo faisait déjà l'objet de procédures à la Cour pénale internationale. La Cour n'est pas incompétente si, dans votre pays, vous avez raison de croire qu'il y a une violation des procès équitables, il y a une violation des droits de l'homme, il y a une violation des libertés publiques, il y a une violation de la liberté d'expression, il y a une violation des instruments internationaux des droits de l'homme. La Cour est compétente, mais elle n'est pas compétente si une autre cour ayant des pouvoirs analogues à la sienne, c'est-à-dire une cour régionale, c'est-à-dire comme la cour de la CEMAC, ou bien la Cour africaine des droits de l'homme, ou bien la Cour européenne des droits de l'homme, ou la Cour américaine des droits de l'homme, a été saisie, la Cour de la CEDEAO déclare son incompétence. Or, il a été rapporté à la Cour par l'adversaire de Mme Simone Gbagbo, donc l'État de la République de Côte d'Ivoire, que Mme Simone Gbagbo faisait l'objet d'une procédure devant la Cour pénale internationale avec son mari, le président Laurent Gbagbo. Par conséquent, la Cour a décliné sa compétence quant à Simone Gbagbo. Mais quant à Michel Gbagbo, la Cour, sur la détention, l'a déclarée illégale et a ordonné sa libération. Donc, la Cour a ordonné la libération de M. Michel Gbagbo. La cinquième affaire, c'est l'affaire Adi Djitoumani Karouan. C'est une affaire qui, on peut dire, ça ne touche pas à la liberté d'expression parce que c'est un monsieur qui a acheté une femme esclave. Il a acheté à 240 000 dans la coutume du Niger. Elle avait 12 ans et il a eu 3 enfants avec cette femme. Et donc, ça s'appelle là-bas, je crois, Sadaka, un truc comme ça. Et donc, il a vécu à la dame et la dame a demandé sa liberté. Et donc, il a écrit un document où il a libéré la femme. Mais matériellement, il a refusé de libérer la femme. Et donc, la femme a saisi le tribunal de l'ONU. Et le tribunal de son lieu de situation a rendu une décision en faveur de la femme et il a fait appel, le mari. Et bon, le concubin, parce que la question du mari va se poser, il a fait appel, la cour d'appel a annulé la décision du tribunal. Donc, elle a fait pourvoi en cassation et pendant qu'elle était en cassation, la cassation a cassé et a ramené l'affaire devant le tribunal. Et pendant tout ce temps, elle s'est mise en ménage avec un nouvel homme qu'elle a marié normalement. Et donc, le mari a saisi le procureur. Le procureur de la République il a fait une plainte contre la dame esclave et son nouveau mari. Et on les a attrapés les deux et on les a mis en prison. Et elle a donc saisi la cour de la CEDEAO, et la Cour de la CEDEAO a dit que l'esclavage est interdit par les lois du Niger et par les lois africaines que le Niger a reconnues. D'abord, la Cour a fait une audience foraine, c'est-à-dire qu'elle est partie à Niamey et elle a entendu des gens, et puis elle est revenue à Abuja et elle a sanctionné et elle a condamné le mari à payer 10 millions de dommages et intérêts à la femme. Je n'ai pas dit les autres dommages et intérêts, si dans les questions j'en viendrai. Et l'affaire numéro 6, c'est l'affaire Moussa Sadikan, que vous connaissez très bien, contre la République de Gambie. Cette affaire-là est liée à l'affaire d'Eida Idara. Parce que Moussa Sadikan, c'est un journaliste et il avait des relations. Donc, il a profité des relations qu'il avait et il a touché le président Thabo Mbeki pour que Thabo Mbeki puisse influencer le président de la Gambie pour que le dossier de l'affaire d'Eida Aïdara, qui est mort, le dossier de sa famille, puisse être traité selon le procès équitable. Donc, les gens du central...
Okay. No, please go on, but maybe if you can wrap up in the next minute or two, that would be great.
Ok, d'accord. Donc, bon, voilà à peu près. Voilà à peu près. Bon, donc, en résumé, que ce soit cette affaire ou l'affaire Pacha et Adema, contre depuis du Togo, ou l'affaire Trustees of Avocats Sans Frontières France, dans l'affaire Frank Gold et Beau, qui était quelqu'un qui devait être exécuté. Et au moment, on s'est rendu compte de l'exécuter qu'il devait être exécuté par fusillade. On pendait les exécutions dans l'État d'Ibo, Edo State, où il était. Donc, on l'a ramené en cellule. Il a profité de ce temps-là pour saisir avec toute cette armada d'avocats la Cour de la CEDEAO qui a estimé que eh bien, la peine de mort, toutes ces choses et tout ce qui entourait cette affaire n'était pas équitable. Et donc, ils ont ramené l'affaire là où il avait. Et enfin, l'affaire Madame Isabelle Ameyanvi, Manavi et autres, l'affaire dite des neuf députés du Togo contre l'État du Togo, où voilà, on a parlé de démission, etc. En résumé, ce que je veux dire, c'est que la Cour de la CEDEAO se présente et se positionne comme une véritable cour qui est ouverte à la saisine des journalistes dans les situations que vous vivez. Que l'État de votre pays, que votre pays ait commencé la procédure, que ce soit une procédure pénale, une procédure civile ou de quelque nature que ce soit, eh bien, les nouveaux textes de la CEDEAO vous donnent le pouvoir de saisir la Cour de la CEDEAO qui statue, en tout cas dans les affaires que j'ai lues là, avec une apparence, une grande apparence d'indépendance, donc avec une indépendance, on peut le dire. Cependant, j'ai fait trois observations. La première chose, c'est de lutter contre l'acceptation préalable de la compétence que la Cour africaine des droits de l'homme a posée par rapport aux actions des ONG et des individus. C'est-à-dire aller d'abord, que l'État soit d'accord, il y a un travail à faire. Il y a un travail de mobilisation à faire pour que la Cour africaine des droits de l'homme abandonne cette façon de faire. La deuxième chose, c'est que la cybercriminalité, l'incrimination de la cybercriminalité partout en Afrique est devenue un nouveau moyen de porter une atteinte sérieuse à la liberté d'expression. Et cela se fait parce que tout simplement, les activistes ne sont pas dans un groupe organisé comme les journalistes. Malgré les protections des journalistes, il y a quelques violations. Alors, les activistes aussi doivent s'organiser, continuer de s'organiser et créer des chartes et créer des éléments éthiques pour permettre cette protection. Et enfin, comme proposition, c'est la loi contre le blanchiment des capitaux, le terrorisme et autres. Dans la plupart des pays africains désormais, les OSC sont classés dans le code de la loi sur le blanchiment et des capitaux et le terrorisme. Il y a un travail à faire pour qu'ils soient séparés parce qu'il s'agit d'une loi répressive comme la loi de la cybercriminalité et c'est une manière détournée de récupérer les anciens comportements, les mauvais comportements qui sont contre les violations de la loi, hein, pour arriver aux finalités de bâillonnement de la presse qui n'ont pas réussi ailleurs. Donc, en résumé, ce que je dis, c'est que désormais, à tout ce qu'on avait déjà en Afrique, s'ajoute la compétence de la Cour de la CEDEAO pour les 16 États de la CEDEAO, les ressortissants, les individus, les ONG, tout le monde peut les saisir et pour agir. Je vous remercie pour votre écoute et je me tiens à votre disposition pour des questions éventuellement.
Thank you so much, Dr. Kone. Thank you. You've shared a lot, and I really like where you have ended up again in terms of the ECOWAS court, and the fact that anyone and everyone can just go to the court to seek redress. And I think what I really like about the ECOWAS court from all that you have said is the fact that their decisions cannot be appealed. So once they take a decision on the issue, then it's more like that is it. And I think it's an opportunity that all of us can take advantage of when seeking redress, when we are attacked, when they attempt to bully us and cow us into submission. I think it's a great mechanism, as you have shared. And you have talked about so many other platforms. Of course, the fact that our own constitutions actually guarantee our rights. And so it should even be a starting point when we are actually fighting for our rights to expression. Thank you so much. I think all of you have shared so much with us, so much knowledge, and we are very grateful. I think we have tried to respond to some of the questions on the Q&A, but I still see 2 hands up. So I'll just go to them right away and then take their questions or comments. In the meantime, let me mention that please don't be quick to leave us. Before you leave, we have a post-webinar survey, and we have put the link to the form, English and French, on the chat. Kindly click on it and then try to give us your feedback. And Dr. Kone, there's a question about legal support or what lawyers can do in the Q&A. I'll be grateful if you could take it up directly and respond to the person. And then I also want to mention that before we end the webinar, we'll share with you a facility the Media Foundation for West Africa has in terms of providing some legal support to journalists and environmental activists who are in danger or persecuted as a result of their work. So please try and stay on and get that information as well before you leave. So quickly, please make your submissions as brief as possible. I'll go to Fatimata Mustafa. Kindly unmute and ask your question. Please be snappy with it. She'll be followed by Monsieur Keita. And then I have, hey, the hands are menu. Please put some of the questions in the Q&A because we've actually overrun the time. So please try and put some of them there. And if you have been responded to or there has been an answer already, please, so that we can wrap up and go. Fatimata, can you just unmute yourself and please make your submission and be snappy with it? Otherwise, then we probably would have to move to the next hand that is up. Okay, while she tries to sort out her microphone and unmute herself, let's please listen to Monsieur Keita. So please unmute and then go ahead with your question. Please go ahead.
Allô, vous m'entendez?
Oui.
OK. Bonjour tout le monde. Bonjour à l'organisation Média Fondation pour l'Afrique de l'Ouest pour cette initiative salutaire qui vise à attirer l'attention d'un plus grand nombre de personnes à travers le continent, à travers le monde sur la situation que traversent les journalistes et les activistes de la société civile qui, dans l'exercice justement de leur métier ou de leur fonction. Je suis Mamoudou Babila Keita, journaliste d'investigation de nationalité guinéenne, aujourd'hui en exil. Je pense que Média Fondation West Africa doit me connaître ou doit être imprégné d'une certaine manière de tout ce que j'ai subi dans mon pays ces dernières années avec l'avènement des militaires au pouvoir. Alors, bien avant je voudrais faire un témoignage parce qu'il s'agit justement des harcèlements judiciaires qui visent à faire taire des journalistes dans l'exercice de leur métier. Je voudrais rappeler ou disons bondir sur un dernier pan de l'intervention du docteur de la Côte d'Ivoire qui vient de finir une brillante allocution par rapport justement à la Cour de la CEDEAO dont la décision est sans appel. Mais je voudrais rappeler également que l'application des décisions de cette Cour dépend de la bonne foi des États membres de la CEDEAO. Nous en avons suffisamment d'exemples parce que il y a eu assez de procès qui ont été tenus, ou disons des Guinéens qui ont engagé des poursuites judiciaires contre l'État de Guinée devant cette cour de la CEDEAO, mais très malheureusement, les décisions qui ont découlé n'ont jamais été appliquées par les autorités guinéennes. Ça, c'est juste une parenthèse. Alors, qu'est-ce que je voudrais dire par là? C'est un témoignage, ce n'est pas une question. Je vais aller très rapidement là-dessus par rapport justement à ce que j'ai subi également, tout ça pour renforcer les différents témoignages qui ont été donnés ou qui ont été faits par les uns et les autres. En 2024, précisément au mois de mars, dans le cadre d'une série d'enquêtes qui portait sur les marchés publics guinéens, l'attribution des contrats publics, qui se trouve être le domaine le plus privilégié par les gouvernants pour procéder au détournement des deniers publics, à opérer de la corruption dans l'attribution de ces marchés-là. Nous nous sommes procurés un certain nombre de marchés sur l'année 2022 et 2023. Et ces marchés ont commencé par le ministère de la Justice parce que le ministre de la Justice lui-même avait fait des déclarations comme quoi qu'il y a effectivement des cas de corruption et des détournements des deniers publics dans le cadre de l'attribution des marchés publics. Et très malheureusement, dans le cadre de nos enquêtes, nous nous sommes rendus compte que le ministère de la Justice n'était pas non plus épargné des cas de corruption. Et donc, on a produit un article sur notre site inquisiteur.net, qui est un média d'investigation, un article qui portait justement sur un certain nombre de marchés passés par le ministère de la Justice en violation du Code des marchés publics en vigueur en République de Guinée, en violation de tous les instruments juridiques qui encadrent les contrats publics. Et à la suite de cette enquête-là, puisque ça visait toutes les institutions de la République, commençant par la présidence, les différents départements ministériels, les régies financières, etc., il avait été ordonné à la haute autorité de la communication de me freiner dans ce élan-là. Et donc, le ministre de la Justice, qui avait été limogé par la suite, a engagé tout de suite une plainte contre moi à la HAC. Malgré la solidité de nos preuves, la HAC a fini par me suspendre pour 6 mois et suspendre mon média pour 6 mois. Donc, on a été interdit d'exercer, j'ai été interdit d'exercer mon métier de journaliste pendant 6 mois, ainsi que mon média. Parallèlement à cela, nous avons engagé, n'est-ce pas, nous avons attaqué cette décision de la HAC devant la Cour suprême de notre pays. Jusqu'où je vous parle aujourd'hui, la Cour suprême n'a jamais examiné notre requête. Et par la suite, puisque je tenais à défendre et malgré la suspension de la HAC, je me suis servi justement de mes réseaux sociaux pour dire que je défends.
Mr. Keita. So I think we have your contact.
Okay.
I may have lost it at some point. Kindly just drop your email in the chat or on the Q&A, and then we can take up the conversation from here and see how best we can come in and
Okay, problem.
Thank you. Thank you so much for sharing this with us.
Okay. Merci à vous aussi. Merci.
Yeah. Okay. So I would move to, I see Meshach Odoi. Please unmute yourself and make a submission. And please be snappy with it. Thank you. Kindly go ahead and make a submission. Okay, whilst Odoi tries to sort out the unmuting issue, and just to maybe let us know, when if you have to unmute, you just go to where your microphone is and it's crossed. So you just click on it and it will uncross, then you can make your submission. Okay, so while you try to sort that one out, let me just draw Dr. Connor's attention to some of the questions on the Q&A that you may have to help us to address. There's one from an anonymous attendee asking whether journalists from the AES region can still have access to the ECOWAS report.
La contribution de notre frère.
Okay, thank you, perfect. Thank you so much. I think Mr. Odoi has still not been able to resolve the microphone issue. So I go to Sadibu Maron. Kindly go ahead and make a submission.
Alors.
Hi, kindly go ahead.
Yes, thank you very much. Merci beaucoup, Laura. Je suis Sadibou Maron, je suis journaliste et défenseur de la liberté de la presse. Je dirige le bureau de Reporters sans frontières et je suis basé à Dakar. Merci aussi à la fondation, à la Media Foundation, comme d'habitude. C'est extrêmement intéressant cette initiative. Je vais rapidement, je n'ai pas de questions particulièrement, mais juste 2 ou 3 points qui, de mon point de vue, nécessitent un peu, disons, une contribution de notre part, notamment un peu les lois du numérique telles que Maître Koné les a abordées tout à l'heure, la cybercriminalité et les autres lois, qui aujourd'hui pour nous, de même que les délits de diffamation et de diffusion de fausses nouvelles, en tout cas dans la région, de ce que nous constatons, sont de plus en plus instrumentalisés par les autorités politiques et les autorités judiciaires et même certains régulateurs aussi pour combattre la liberté de la presse et aussi pour maintenir des journalistes en prison. Ça, c'est aussi des faits qui de plus en plus émergent et qui, de notre point de vue, nécessitent un peu d'ajouter un peu dans la discussion générale. C'était mon premier point. Mon deuxième point, c'est en rapport avec les réseaux d'avocats. Pour nous, c'est intéressant un peu. Je pense que le réseau mis en place par la Media Foundation nous semble très dynamique. RSF avait également mis en place un réseau plus ou moins similaire. Mais en parlant de réseau, pour nous, ce qui est important, et c'est le mot-clé qui a été développé par Edith tout à l'heure, c'est pro bono. Même si c'est pro bono, cela nécessite également des coûts. De notre point de vue et de notre analyse, dans la pratique des réseaux, tout le monde n'est pas, par exemple, Maître Koné, qu'on retrouve avec beaucoup de plaisir. Tout le monde n'est pas probablement médecin au Sénégal. Il y a de plus en plus beaucoup d'avocats très engagés et qui peuvent travailler pro bono sur des cas de SLAP, de litigation stratégique. Mais de ce que nous avons remarqué en pratique, c'est que même déplacer un avocat, par exemple, de Guinée à Abuja pour la Cour de justice de la CEDEAO, c'est pas moins de 2 000 euros, c'est peut-être 3 000, même si l'avocat sera pro bono. Donc, le mot-clé, c'est pro bono, mais le nerf de la guerre, c'est l'argent. D'où l'importance d'essayer de penser un peu à comment faire pour fédérer de plus en plus un peu les initiatives des réseaux qui existent ici ou là, pour avoir un peu des approches stratégiques, parce que l'impact qu'on recherche, en fin de compte, c'est qu'un journaliste soit libéré de prison, ou bien qu'une cause, ou bien qu'une litigation soit, disons, qu'il y ait une victoire sur une litigation, qu'un journaliste soit libéré de prison. Donc, c'est le plaidoyer que je voulais rappeler, et puis vous remercier encore pour cette belle initiative, et restant à votre disposition pour le futur. Merci et bonne journée.
Okay. I would speak briefly about some of the points you made mention of, but let's take the other questions, and then when we are addressing, we can address all. Thank you so much. So we move to Keba Diallo, and please try and make it snappy for us. Keba, thank you. So please unmute and go ahead with your question. Keba, you have the mic. Unmute. Okay, thank you.
Oui, bonjour.
Oui, bonjour.
Je rejoins vraiment le camarade et ça fait très longtemps que je cherchais son contact, le camarade de la Guinée-Conakry, un ami dont on a eu le temps de s'écrire, mais malheureusement, j'ai pas pu garder son contact. Je suis Keba Ibrahim Diallo, journaliste et responsable du site West Af Media. Ici au Mali, il y a trop, actuellement même, on peut dire que la liberté de presse, comme c'est partout en Afrique. Mais je voulais juste vous demander aujourd'hui s'il y a un texte pour les journalistes qui peut nous protéger et quelles sont les mesures que nous, les journalistes, ou s'il y a les formations pour nous, les journalistes, pour éviter vraiment toute tentative des pièges posés par la cybercriminalité présentement au Mali. Merci beaucoup. J'en ai terminé.
Thank you very much for your submission about the cyber issues. So I think that brings to two. You have talked about it, and the speaker before you also did. I don't know, maybe hopefully Dr. Kone and Mr. Ojo would be able to speak to those as well for us. Let me jump and go to Gil Yao. I hope I've mentioned your name right. Kindly unmute and make a submission. Janet and Meshach.
Hello.
I've granted you the opportunity because of time. Just put your questions in the Q&A, please. Okay, thank you.
Hello.
Okay, Yao, please go ahead.
Yes, ok. Bonjour à tous. Très heureux d'avoir cette opportunité de participer à ce panel, à ce webinaire-là. Et je pense que c'est très important pour les entreprises, les médias de l'Afrique et du monde de pouvoir avoir des mécanismes, des instruments de protection, de défense et de promotion des droits. Surtout que le contexte actuel dans la sous-région ouest-africaine est extrêmement délicate. Enfin, il y a un contexte très délicat et donc on pourrait se poser des questions, bon, comment agir dans un tel environnement médiatique où les libertés font face au pouvoir étatique, où les questions liées aux droits de l'homme sont un peu très, je veux dire, sont pas bien menées, sont pas bien encadrées. Quel mécanisme juridique, voilà. Et donc, je pense que tout ça, c'est une question, et moi, c'est la solution que je propose. C'est une question de réseautage et de mise en place de mécanismes juridiques. Et voilà, quand j'ai écouté M. Kone, et là, on peut avoir le sentiment de craindre un peu pour mener à bien nos activités en tant que dirigeant d'entreprise de presse. C'est pour cela que moi, en ce qui concerne mon entreprise de presse, je joue la carte de la prudence. C'est très compliqué de mettre en œuvre sa vraie liberté d'expression sans être l'objet de brimades, enfin, d'intimidation, même subtil et indirect. Et voilà, les entreprises de presse sont-elles viables dans notre sous-région? Voilà. Ce qu'on observe, il n'y a pas de... Vraiment, il n'existe pas encore, je n'ai pas encore vu, et s'il y en a, bon, je pourrais m'engouffrer et être membre de ce réseautage-là, de cette plateforme, pour qu'on puisse défendre les droits, la liberté d'expression, les droits de l'homme, les droits des journalistes. et des activistes. J'observe ici dans mon pays que ce n'est pas toujours le cas. Voilà. Et donc, ça nous donne des situations de prudence, d'agir prudemment et à la limite, ça fait que nos entreprises ne sont pas viables. Voilà, sont pas viables et voilà. Et donc, nous sommes tenus de faire vraiment attention. Et bon, voilà. Donc, réfléchissons. Et puis, je pense que la solution, ça sera dans le réseautage, dans la mise en place d'instruments juridiques, de mécanismes. Il faut que les organisations de la société civile jouent pleinement leur rôle avec nous, associés. Voilà, parce que franchement, si on ne joue pas notre rôle, on va se faire toujours harakiri. Voilà, donc vraiment, mes félicitations et j'espère que les autres intervenants vont pas maintenir rigueur par rapport à l'expression française. Mais bon, voilà, une prochaine fois, on tâchera
Thank you.
de parler anglais. Voilà, merci et bonne continuation.
It's fine. No, it's fine. It's perfect. It's fine. At least we've gotten the message you are putting across. And the concern you raise about how sometimes these issues and challenges end up forcing us into some form of self-censorship is real. And I think Mr. Ojo can speak to that when we are about wrapping up. Let me just take one last question. So there's one Mr. Odoi. In fact, I have two Mr. Odoi. So the first one, please go ahead. I just allowed you to speak. Just unmute and go ahead, please. And we don't really have time. So if it's a challenge, then we'll just have to move on. So,
bonjour.
Oui, bonjour, monsieur.
Bonjour à tous. Vous m'entendez?
Oui. So your name?
Mon nom c'est Alain Aïmou. Je n'ai pas compris vraiment pourquoi j'ai ce pseudo. Donc, je m'appelle Alain Aïmou, je suis journaliste d'investigation ivoirien. Vous m'entendez?
Oui.
Voilà. Je voulais intervenir particulièrement sur la liberté des médias publics sur notre continent africain. Alors, il s'avère que par exemple, en Côte d'Ivoire, le président de la République, d'abord, il faut que j'explique, les médias publics sont pour moi une bonne raison de faire en sorte que le journaliste d'investigation soit libre. Parce que la plupart du temps, dans ces médias publics, comme chez nous, la RTI, ils sont caporalisés. Et parce qu'ils sont caporalisés, il est quasiment impossible de voir de l'investigation ou de l'enquête sur ces médias. Alors, ça finit par mettre dans la tête des populations que l'investigation, c'est un métier presque à part qui n'a pas sa raison d'être. Alors, si éventuellement on arrive à libérer ces médias publics pourront produire des investigations et légitimer ce métier qui est en quelque sorte martyrisé et dégradé par les autorités. Et ça va légitimer cela au niveau des médias privés. Alors, à la réalité, ces médias publics sont caporalisés parce que les textes de la Charte africaine des droits de l'homme qui exigent qu'il y ait une liberté entre des médias publics, parce que l'exécutif ne doit pas avoir d'influence sur ces médias publics, ces textes ne sont pas respectés. Par exemple, en Côte d'Ivoire, le président de la République, il nomme le directeur de la télévision nationale, le directeur de la radio, le directeur des organes de régulation. Alors, il a un pouvoir énorme sur ces structures. Notamment, il a le pouvoir aussi de les renvoyer à sa guise. On l'a déjà vécu plusieurs fois en Côte d'Ivoire. Alors, ça ne permet pas à ces médias publics de travailler comme des journalistes libres. Et par conséquent, cette caporalisation, ça a un autre impact sur le travail des journalistes d'investigation, dans le sens où lorsqu'un journaliste d'investigation produit une enquête, ces médias publics ne peuvent pas en parler. Et quand ils ne peuvent pas en parler, ils enlèvent de la crédibilité à leur travail. Parce qu'un média public a quand même, au regard des populations, une certaine crédibilité. Donc, j'attire l'attention sur le fait que Pour ce qui concerne l'environnement médiatique de nos pays, il faudra faire en sorte, parce que déjà il y a des tests qui existent, pour que ces médias publics soient libres. Parce que j'ai l'impression qu'on a fini par accepter dans beaucoup de pays et dans l'esprit d'intellectuels comme de populations que ces médias publics sont, comme on veut le faire croire en griffe, des médias d'État, ce qui n'en est aucunement le cas. Des médias publics sont des médias de service public et qui doivent servir à toute la population de façon indépendante et libre. J'en ai fini, merci beaucoup. Allô?
Thank you very much for sharing this with us. As you also share your experiences, we also pick lessons, and then we see how best we can strategize together in addressing some of the issues that you have raised. I think I'll give the last chance to Bala Kamara, and please go ahead and make your submission. When he is done, just some few, we'll take some responses from Dr. Kone and Mr. Ojo, and then I'll also share, as I said, the intervention we are making available for legal support to some of us who are under threat or are being persecuted. Thank you. Bala Kamara, please go ahead.
Merci de m'avoir donné la parole. Moi, je parle du cadre juridique ici au Mali. C'est très, très difficile. Il n'y a pas de texte qui protège les journalistes ici, comme a témoigné mon confrère Kiba Diallo. Ici, tout est, les hommes de médias, les journalistes, on a élaboré beaucoup de textes qui sont aujourd'hui sur la table du président de la transition, certains au niveau du CNT, Conseil national de transition, l'organe législatif aujourd'hui. Mais il n'y a pas de textes qui résistent la protection des journalistes. Il y a des associations, on fait des bons travail, on élabore des textes, mais l'adoption et la promulgation pose problème. Maintenant, il s'agit pour nous qui ne sommes plus, nous les journalistes maliens qui ne sommes plus membres de la CEDEAO. Qu'est-ce que vous pouvez nous apporter en termes de protection pour qu'on puisse travailler dans la tranquillité, puisque nous sommes face à des textes de cybercriminalité qui ne nous met pas à l'aise dans l'exécution de notre travail. C'est très, très difficile ici chez nous, parce que nous sommes confrontés à beaucoup de problèmes. Ici, la pollution de l'environnement dit à l'exploitation illégale de l'or, les compagnies étrangères présentes ici chassent les populations de leur terre, puisque c'est l'agriculture, l'élevage et la pêche qui sont les activités principales exercées par les populations. Si les populations sont chassées de ces terres-là, qu'est-ce qu'ils vont faire? C'est très difficile. Bon, quand on essaie de travailler sur ces sujets, on ne parvient pas. C'est très difficile ici, le journalisme d'investigation. Merci, c'était mon témoignage.
Thank you very much for sharing this with us. We understand the terrain is a bit challenging, but again, through these conversations, we seek to share knowledge and ideas with the hope of finding strategic ways of going around them and getting the work done. And Bala, kindly drop your email address in the chat so that we can possibly take some of the conversations forward. Dr. Konde and Mr. Ojo, kindly help us to respond to these questions. Some of them are questions, some of the, especially the issues around the exploitation of cyber crimes and questions around the AES and the ECOWAS. And others are just comments about how we can get legal resources to help, and the other comments in the questions in the Q&A. So I'll first take Dr. Kone and then Mr. Ojo will follow. Thank you.
Merci beaucoup, Madame Dora. Sur la cybercriminalité, ce que je voudrais dire, c'est que la cybercriminalité a deux types d'infractions. Grosso modo, des infractions qui sont des infractions du droit commun et qui s'étendent par le moyen, parce que le cyberespace est un moyen de communication, donc qui s'exprime ou qui se déploie ou qui a des répercussions dans le cyberespace. Et il y a les infractions qui sont des infractions qui sont nées avec le cyberespace. Et les infractions qui sont la diffamation normale qu'on peut faire par presse, on peut l'amplifier par le réseau des réseaux, c'est-à-dire l'Internet. Et on peut aussi aller sur le web et tout ça. Et puis, il y a les infractions qui sont sur le web, c'est le fait, par exemple, de prendre un message dont on n'a pas fait suffisamment le fact-checking, on n'a pas fait le double-checking, et puis on balance à d'autres personnes, on se retrouve emballé dans un processus de communication où nous devenons à notre tour auteurs avec celui qui a initialement créé ce message. Alors, ce que je voulais dire, c'est comme il a été dit, hein, tout ce qui se fait à l'éthique. Nous ne sommes pas pour l'impunité totale, nous sommes pour la liberté. Et la liberté, les droits de l'homme, la liberté d'expression contient les droits de l'homme. Il y a les droits des personnes, il y a certaines choses qu'il faut respecter, tout ça. Cependant, ce que je voulais dénoncer aujourd'hui, c'est que la cybercriminalité devienne un moyen de poursuivre des infractions qui, dans le droit normal, c'est-à-dire ici, ne sont plus poursuivables. C'est-à-dire simplement parce que la loi les a double incriminés ou les a incriminés pour que ceux qui sont sur le cyber n'échappent pas et qu'on va prendre des journalistes qui sont sur le cyber et leur faire des arrestations, des gardes à vue, les condamnations pénales, alors que la dépénalisation est le principe de la Charte africaine des droits de l'homme. Et cette Charte africaine des droits de l'homme s'impose à tous les pays signataires de traités de l'Union africaine. Donc, il ne peut même pas se dérober dans par rapport à cette disposition. Donc, l'encouragement, c'est que nous puissions nous-mêmes travailler à démêler, à distinguer, à différencier entre les infractions qui sont proprement cybernétiques et les infractions qui ne le sont pas, mais qui sont la continuité et dont la répression est un détournement des procédures pour pouvoir faire dans le cyber, avec la loi de la cybercriminalité, ce que la loi sur la presse ne permet pas de faire à un journaliste. Et quand cela arrive, c'est tellement subtil que la démonstration, on pense que c'est un parti pris préalable qui conduit à la démonstration. Mais pourtant, elle existe et les juridictions vont aller dans ce sens. Quant à l'application des décisions de la justice, l'application des décisions de la justice, mais c'est un défi dans le monde entier, partout, c'est une affaire de vie. Les décisions qui ont été rendues par la Cour européenne des droits de l'homme, qui ont été boycottées par des États qui sont des États des droits de l'homme, comme la France, par des États d'autres, etc., qui n'ont pas voulu se soumettre. Mais le fait que ces décisions existent, celui qui s'appuie sur ces décisions dans ces pays pour agir, il est dans une sorte de légalité, il n'est plus un persécuté, un pestiféré. Et donc, du fait que ces décisions de la CEDEAO existent, le journaliste n'est pas seul avec son bagage. Les décisions économiques, les décisions civiles qui sont rendues chaque jour devant les juridictions, mais ont le même défi, il faut les exécuter après. L'exécution, c'est la résistance à celui qui doit bien, se soumettre. Le principe de droit, c'est quoi? Lorsque vous êtes condamné à une décision, vous n'attendez même pas qu'on vous signifie, vous l'exécutez. Et quand on vous signifie, c'est comme si vous aviez oublié, vous dites, je vais l'exécuter et vous en donnez les preuves. Or, qu'est-ce qu'on voit? C'est l'État que nous avons en face. Vous l'avez dit, l'État est puissant, l'État est l'entité aujourd'hui qui a été admise dans le Conseil des Nations comme le seul moyen pour gérer un groupe civilisé d'individus. Il y en a d'autres moyens, mais on estime que c'est le meilleur moyen. Alors, les États de l'AES qui sont sortis de la CEDEAO, d'abord, le retrait de l'AES, des États de l'AES, c'est un retrait politique. Parce que le retrait juridique, le retrait opérationnel n'a pas encore été porté jusqu'à son paroxysme, jusqu'à sa finalité, jusqu'à ses éléments définitifs. Pourquoi? Parce qu'il y a encore des fonctionnaires de ces pays qui sont dans les structures de la CEDEAO. Il y a encore des communications, il y a encore des entretiens par rapport avec ces pays. Donc, pendant qu'il y a ces entretiens et qu'il y a ces choses, tout ce qu'on peut subir, il faut saisir cette cour. Et en même temps, si elle vous dit qu'elle est compétente, il faut saisir la Cour africaine des droits de l'homme si vos États ne sont pas retirés de la Cour africaine des droits de l'homme. Mais ça participe même de la difficulté qu'on donne à ces pays par rapport à ces droits. On ne peut pas rester sans rien faire face aux brimades qui sont faites aux journalistes. Donc, à ce niveau, on doit faire quelque chose et je propose, comme a dit Sadibou Marong, que, eh bien, il y ait également un travail qui soit fait, un réseau non seulement d'avocats pour la justice, mais un réseau de journalistes de haut niveau, de haut vol, un réseau Media Foundation en fait déjà, mais qu'on puisse s'entendre et que Media Foundation soit appuyé pour que, puis de façon stratégique, on puisse préparer des travaux comme on le fait et continuer l'instruction avec les uns et les autres. Donc, j'ai répondu, c'est la question des médias publics. La question des médias publics, la loi, par exemple, la loi ivoirienne sur les médias publics, je vous dis quelque chose d'extraordinaire. C'est que quand on fouille le droit sénégalais, quand vous regardez les textes, tout ça, vous allez voir que les textes ne sont pas vraiment, vraiment en faveur de la liberté. Par contre, l'exercice de la liberté par les juges sénégalais, mais c'est indiscutable. Ils donnent même aux individus des choses qui n'existent souvent pas dans les textes qu'ils exécutent, mais qui existent dans le droit sénégalais. Donc, il y a un courage des juridictions qu'il faut arriver à saluer et qu'il faut permettre d'aller de l'avant. En droit ivoirien, par exemple, pour les médias publics, il y a une réglementation assez rigoureuse qui demande que, bon, il y ait une convention entre l'État et un cahier des charges, il faut des choses, etc., des procédures, il y a des processus, etc., etc. Mais l'État et les violateurs des droits de l'homme et de la liberté d'expression, mais ils ont toutes sortes d'idées, ils sont très créatifs quand il s'agit de dévier les textes, etc., etc. En plus, ceux qui bénéficient des textes, eh bien, ce qui les intéresse, c'est de signer le contrat de travail. Ils ne pensent même pas à les visiter, à les regarder, à les comprendre, à les analyser. Donc, c'est tout à fait normal qu'ils soient souvent le jouet de l'autorité publique, qu'ils soient le jouet. Mais si ce n'est pas l'État qui nomme, les organes de l'État qui nomment les gens à ces fonctions, qui va les nommer? Qui va les nommer? Parce que aujourd'hui, l'ANP, l'Autorité nationale de la presse, est protectrice de la presse parce qu'il y a des défenses que nous avons faites. Je ne dis même pas par rapport à quoi que ce soit. Je dis, bah, c'est ce qui s'est passé. Je donne un exemple très banal. Il y a un journaliste qui a écrit, il avait une revue ici à caractère pornographique. Et puis la police décide, sans le procureur, d'arrêter tous les gens, de les envoyer chez eux pour dire que c'est un truc de mœurs. Alors qu'ils ont respecté toute la réglementation. Donc, je suis allé avec la loi, avec mon livre, pour leur expliquer que voilà ce que dit la loi, voici ce que dit le droit et tout ça. Dit, ah, moi, ça ne savait pas. Mais ils ont appelé le procureur pour s'en assurer. Et il a fallu que nous allons avec des gens de l'ANP. Voilà la structure de l'État qui fait les choses, qui a un pouvoir disciplinaire, qui vous dit qu'ils ont le droit de le faire. Parce que ces gens, ces services de l'État qui sont dans les brimades, ont besoin à un moment donné aussi d'entendre des gens qui sont dans les services analogues à leurs services, qui ont les mêmes fonctions, les mêmes réalités, pour leur dire que ce que vous faites là n'est pas bon. Il faut plusieurs foyers de lutte et de défense de la liberté de la presse. Il faut des foyers indépendants, il faut des foyers privés, il faut des foyers d'ONG, il faut des foyers d'activistes, il faut aussi des foyers d'individus ou de services qui sont dans le système et qui sont reconnus par l'État comme étant dotés de ce pouvoir. Sur les médias publics, je pourrais dire beaucoup de choses, mais je m'arrête là. Voilà. On ferait plus aussi s'exprimer en vous vos questions.
Thank you. Thank you. Mr. Ojo.
Okay, thank you very much. I'll try to be very brief and I'll just respond to two issues. The first, with respect to the widespread misuse of cybercrime, cybersecurity laws. I think there is a lesson for us to learn here as a community. And that lesson is the fact that when these laws are in process, when they are being considered for enactment, we don't engage those processes to identify those laws are passed, and we then find either smuggled into them or them. But because we did not engage with the process, we did not realize it until after they became law. But even now, I think that it's important that media practitioners continue to focus on the issue and demonstrate the fact that these laws are being misused. They're not really being used for the purposes for which they were enacted, which is to combat cybercrime or promote cybersecurity. What does that mean? The reality then becomes that because they're being abused, cybercrime is on the rise because you are diverting a resource that should have been used to combat cybercrime to go after journalists and activists and people who are criticizing government. And I think that the media can demonstrate this quite easily by showing the track record, the statistics of number of people who are arrested and prosecuted, how many of them are actually cyber criminals versus how many of them are people who have been arrested for expressing their opinions. And then also using available instruments and mechanisms to challenge them. Domestic law may be problematic, but our colleague referred extensively to decisions of the African court, including in the Konate case. And I think that those are avenues that countries that have either judicial systems that are not independent or do not promote or protect human rights, we can begin to look to other mechanisms at the regional and international levels to see the extent to which we can use them. The same manner that Issa Konate was able to use the African court to overturn the very oppressive judicial process in Burkina Faso. So I think that those are lessons that we need to learn. And it also leads me to the question that Balak Kabara raised with respect to Mali, where he says, we currently do not have text that promotes or protects media freedom. In the same way, I think that we should look at regional instruments that can be utilized in the absence of national laws. I know that there is a lack of certainty as to whether ECOWAS frameworks currently apply to Mali along with the other countries that have withdrawn from ECOWAS. But the African Commission and the African Court continue to be applicable. So those are avenues. Following in the precedent set in the Konate case, I think it will be pretty easy to pursue similar pathways at the African Court and certainly at the African Commission. And this is again where we can also talk about regional solidarity. Once those cases are going on, the issue can be amplified within the political leadership of the African Union. So we really need to explore opportunities that exist outside of national frameworks and domestic courts where they're not working for us.
Oh, sorry.
Thank you.
Thank you so much, Edith. Thank you, Dr. Kone. Thank you, everyone. It's been an insightful session. I mean, so much to learn, so many recommendations made. We are wrapping up at this point, and I would want to assure you that the recommendations that have been made here, we'll put them together in a publication and share. And we'll also share a link to the recording of this webinar to the email addresses that you used in registering for the webinar. In the meantime, I would kindly request that you use the link provided in the chat to give us feedback on your key takeaways from this webinar. I think someone raised issues about having the legal networks and the challenges with resources in terms of the fact that if one is based in this country and then then there's a need to fly people in and all that. For the WANAMDEL network, at least for now, we have a membership of about 14 esteemed lawyers based in 11 or 12 countries across the region, which means we just have a few more to cover. And what it also means is that for each of these countries, we will not necessarily need to fly people in. We have equally competent lawyers in those countries who can support. And the issue about pro bono and all the other things, yes, we have considered all that. So pro bono in terms of maybe the actual legal service that would have had to pay. But of course, the administrative charges, you can't put all on the lawyer in the name of pro bono. So some of those administrative issues are also taken care of with this kind of support. So if you are in need and if you have to actually reach out to any of these lawyers, just let us know and we would link you up. Depending on the nature of the situation or the case, we would decide with the lawyers how to proceed. And having mentioned that, let me also say that the Media Foundation for West Africa has some level of support for persecuted journalists and environmental activists who are in dire need of legal support. We'll just put the flyer, we'll share it on the screen so that you have a look. But we would also publish it on our website and our social media platforms. Today, you can have a look at it and then reach out so that we can see how best we'll support. Let me mention that the facility available is relatively small, and so we'll not be able to cover everyone, but it will be based on needs. I mean, the urgent dire needs would be the ones to be addressed first, and then we would seek more support to help in resolving all the others. Special thanks to our frontliners and our speakers who have committed a little over 3 hours of their time to share their experiences and their knowledge with us. And we are so grateful for all that you have shared. What we would have to practicalize, what we have to strategize around, where we have to come together, we will come back to you and collectively find solutions to the many challenges that we have outlined. We'll be on the call for some few minutes. If you still have some specific comments or questions you want to put across, you can put it on the Q&A and we'll try and respond to them. And before we leave, we'll play the video we started with again, the one about the WANAMDEL, the lawyers network, so you get to know which country and which lawyer in your country you can go to. Of course, Dr. Kone is here for Cote d'Ivoire, so I think for the Ivorians, at least you know the legal person you can reach out to, but of course you talk to us and then we also reach out to them and then we find a way to support. And then we'll also play the video on how to avoid defamation suits. Very important. Quite a number of the things that have been highlighted here have also been mentioned in the video. Let's all try and keep to truth, to facts, to evidence, and make sure that as and when we can, we as much as possible try to avoid these legal threats. But where they come, then we work together and find solutions. Enjoy the rest of your day. Thank you so much for spending your morning with us. We are grateful. Bye-bye.
Laura, please, can they turn on their cameras for a quick screenshot?
Oh, yeah. I nearly forgot. Please, apologies. Kindly turn on your cameras. I think Michael should have fronted me earlier. Please turn on your camera so that we can take a good photograph. And give us a nice smile, if you can. Yes, Michael, I'm not seeing you. Seth, at least the names I can mention, I'll mention. But otherwise, please, everyone, kindly put your camera on. Let's have a good photograph. Michael, smile. And let us know when you are done.
I'm done.
Okay, thank you. Thank you, everyone. Enjoy the rest of your day. We are grateful.